ಪಾಯಿಂಟ್ ಏನಪ್ಪ ಅಂದರೆ ಸ್ವಲ್ಪ ಕೇಳ್ರಿ. ಇದು ಸಾರಿ ಲೇಟ್ ಆಯ್ತು ಇವತ್ತು ಸ್ವಲ್ಪ ನೋಡಿರಿ. ಆಲ್ಮೋಸ್ಟ್ ಏನಪ್ಪ ಇದು ಟೈಮ್, ಮೊದಲು ಸ್ಟೂಡೆಂಟ್ಸ್ ಎಕ್ಸಾಮ್ ಟೈಮ್ ಇದು. ಈಗ ಕೇಳ್ರಿ, ಬಿಕಾಸ್ ಒನ್ ಬೈ ಒನ್ ಸಿಸ್ಟಮೆಟಿಕ್ ಕಾಲ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತೀನಿ. ಡೌಟ್ಸ್ ಇದ್ರೆ ಪ್ಲೀಸ್ ಕೇಳ್ರಿ. ಐ ಲವ್ ಟು ಆನ್ಸರ್ ಯುವರ್ ಡೌಟ್ಸ್ ಬಚ್ಚೋ, ನಾಟ್ ಅ ಪ್ರಾಬ್ಲಮ್. ಸೊ ನೋಡಿ, ವಾಟ್ ದೇ ಸೇಡ್ ಇಸ್ ದ್ಯಾಟ್, ಏನು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂದರೆ ಎಕ್ಸಾಮೈನ್ ವಿತ್ ರೀಸನ್, ರೈಟ್? ರೀಸನ್ ಕೂಡ ಎಕ್ಸಾಮೈನ್ ಮಾಡ್ರಿ. ಗಿವನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಈಸ್ ಕರೆಕ್ಟ್ ಆರ್ ಇನ್ಕರೆಕ್ಟ್. ಸ್ವಲ್ಪ ನೀವು ಕೂಡ ಆನ್ಸರ್ ಮಾಡ್ರಿ ನಾನು ಕೂಡ, ಬಿಕಾಸ್ ನೀವು ಲಾ ಓದಿರೀಗ, ನಾನು ಕಲ್ಸಿದ್ದೀನಿ ಇದನ್ನ. ಬಟ್ ಆದರೂ ನೀವು ಕೂಡ ಸ್ವಲ್ಪ ಆನ್ಸರ್ ಮಾಡ್ರಿ. ಈಗ ಏನಂದರೆ ಅ ಮೈನರ್ ಈಸ್ ಲೈಬಲ್ ಟು ಪೇ ಫಾರ್ ನೆಸೆಸರೀಸ್ ಆಫ್ ಸಪ್ಲೈ ಟು ಹಿಮ್. ಇದು ಕರೆಕ್ಟ್ ಇದೆಯೋ ಇಲ್ಲ? ಇದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕರೆಕ್ಟ್ ಇದೆ ಇಲ್ಲ? ಟೆಲ್ ಮಿ ಗೈಸ್, ಈಸ್ ದಿಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಈಸ್ ಕರೆಕ್ಟ್ ಆರ್ ನಾಟ್? ಕರೆಕ್ಟ್ ಇದ್ರೆ ಟು ವಾಟ್ ಎಕ್ಸ್ಟೆಂಟ್ ಬಚ್ಚೋ? ರಾಂಗ್ ಇದ್ರೆ ಟು ವಾಟ್ ಎಕ್ಸ್ಟೆಂಟ್? ಟೆಲ್ ಮಿ ಪ್ಲೀಸ್, ರೆಸ್ಪಾಂಡ್ ಮಾಡಿ ಫಾಸ್ಟ್ ಆಗಿ. ಕರೆಕ್ಟ್ ಇದೆ ಇಲ್ಲ ಅಂದರೆ ಏನು ಹೇಳ್ತಾ ಇದ್ದಾರೆ? ವಾಟ್ ದೇ ಆರ್ ಸೇಯಿಂಗ್ ಇಸ್ ದಾಟ್, ಸ್ವಲ್ಪ ಕೇರ್ಫುಲ್ ಆಗಿ ಕೇಳ್ರಿ. ಎಕ್ಸಾಮೈನ್ ವಿತ್ ದ ರೀಸನ್ ದ ಸ್ಟೇಟ್ಮೆಂಟ್ ಈಸ್ ಕರೆಕ್ಟ್ ಆರ್ ನಾಟ್ ಆರ್ ಇನ್ಕರೆಕ್ಟ್. ಮೈನರ್ ಇದೆಯಲ್ಲ, ಅವನಿಗೆ ನಾವು ನೆಸೆಸರೀಸ್ ಆಫ್ ದಿ ಲೈಫ್ ಸಪ್ಲೈ ಮಾಡಲಿಕ್ಕೆ ನಾವು ಅವನಿಗೆ ಕೊಡ್ಬೇಕಂತ ಹೇಳ್ತಾರೆ ಅವರು, ರೈಟ್? ದೇ ಆರ್ ಆಸ್ಕಿಂಗ್ ಟು ವಿ ಶುಡ್ ಪೇ ಹಿಮ್. ಸೊ ಈಗ ಆನ್ ವಾಟ್ ಗ್ರೌಂಡ್? ಸ್ವಲ್ಪ ನೋಡ್ರಿ, ಮೇ 18 ಕೊಟ್ಟಿದ್ರು ಅವ್ರ ಕ್ವಶನ್ನ ನೋಡ್ರಿ. ಹೌದಪ್ಪ, ನೋಡ್ರಿ, ನೆಸೆಸರೀಸ್ ಅಂದ್ರೆ ಏನ್ರಿ? ಈಗ ಫುಡ್ ಆಯಿತು, ಶೆಲ್ಟರ್ ಆಯಿತು, ರೈಟ್? ಎಜುಕೇಷನ್ ಆಯಿತು, ಮೆಡಿಕಲ್ ಆಯಿತು, ಅದೆಲ್ಲ ನೆಸೆಸರಿ ಬರ್ತದಲ್ಲ ಅದು, ಹೌದಲ್ರಿ? ಅಂದರೆ ಮೈನರ್ ಈಸ್ ಲೈಬಲ್ ಟು ಪೇ ಫಾರ್ ನೆಸೆಸರೀಸ್ ಸಪ್ಲೈ ಟು ಹಿಮ್. ರಿಮೆಂಬರ್ ದಿಸ್. ಸರ್ ಹೆಂಗೆ ಸರ್? ದಿಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಈಸ್ ಇನ್ಕರೆಕ್ಟ್, ರೈಟ್? ದ ಕೇಸ್ ಆಫ್ ನೆಸೆಸರಿ ಸಪ್ಲೈ ಟು ಮೈನರ್ ಆರ್ ಎನಿ ಅದರ್ ಪರ್ಸನ್ ಹೂ such minor is legally bound to support the governed by the section 68 of the Indian contract. ಏನು ಹೇಳ್ತಾ ಇದೆ ಅಂದರೆ, a claim for necessary supplied to a minor is enforceable by law. Claim for necessary supplied to a minor is enforceable by law. ಅಂದ್ರೆ only against the minor estate if he possess. ಅಂದ್ರೆ ಈಗ ಮೈನರ್ ಹತ್ರ ಏನೋ ಒಂದು ಎಸ್ಟೇಟ್ಸ್ ಇದಾವೆ, ಏನೋ ಪ್ರಾಪರ್ಟಿ ಇದೆ, he is a owner of some property. On that ground he can ಏನಪ್ಪ, he can enforce. But minor is not liable to pay any price that he may promise, and never for more than the value of the necessaries. Value of the necessaries ಗಿಂತ ₹1 ಹೆಚ್ಚಿಗೆ ಕೊಡಂಗಿಲ್ಲ. So there is no personal liability of the minor, because ಮೈನರ್ ಕೂಡ ಯಾವುದೇ ಥರದ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಇನ್ವಾಲಿಡ್ ಆಗುತ್ತೆ. ಬಟ್ ಓನ್ಲಿ ಹಿಸ್ ಪ್ರಾಪರ್ಟಿ ಈಸ್ ಲೈಬಲ್. ಇದರ ಅರ್ಥ ಏನ್ರಿ ಸರ್? ನೋಡ್ರಿ, ಮೈನರ್ ಈಸ್ ಲೈಬಲ್ ಟು ಪೇ ಫಾರ್ ನೆಸೆಸರಿ ಸಪ್ಲೈ ಟು ಹಿಮ್. ದಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಈಸ್ ಕಂಪ್ಲೀಟ್ಲಿ ಇನ್ಕರೆಕ್ಟ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಓಕೆ, ಯಾಕೆ? ದ ಕೇಸ್ ಆಫ್ ನೆಸೆಸರಿ ಸಪ್ಲೈ ಟು ದ ಮೈನರ್ ಆರ್ ಎನಿ ಅದರ್ ಪರ್ಸನ್ whom such minor is legally bound to support his governed by section 68 of the Indian Contract Act 1872, right? 1872. ಈಗ ಅಂದ್ರೆ ಏನು ಇದರ ಅರ್ಥ? ಈಗ ನೋಡಿ, ಈಗ ಒಬ್ಬ ಮೈನರ್ ತಾನಿಲ್ಲಿ, ರೈಟ್? ಈ ಮೈನರ್ ಹತ್ರ ಎಸ್ಟೇಟ್ ಇದೆ, ಪ್ರಾಪರ್ಟಿ ಇದೆ, ರೈಟ್? ಮತ್ತೆ ಆನ್ ದಟ್ ಎಸ್ಟೇಟ್ ಅಂಡ್ ಪ್ರಾಪರ್ಟಿ ಬೇಸಿಸ್, yes, he can claim for necessaries of the life. Necessaries of the life, very important. ಈಗ necessaries are basics, education, food, medical allowance, all that, right? ಹಾಗಿದ್ದರೆ ಇದು ಬಿಟ್ಟು ಬೇರೆ ಯಾವುದ್ರ ಕೇಳಕ್ಕೆ ಬರ್ತೈತೇನ್ರಿ? ಇಲ್ಲ. ಸೊ ಏನು ಹೇಳ್ತೈತಿ ಇಂಡಿಯನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್ 1962, ಅ ಕ್ಲೇಮ್ ಫಾರ್ ನೆಸೆಸರಿ ಸಪ್ಲೈಡ್. ಈಗ ಮೈನರ್ ಏನು ನೆಸೆಸರಿ ಸಪ್ಲೈ ಮಾಡಿರ್ತಾರಲ್ಲ, ಈಗ ಉದಾಹರಣೆಗೆ ಇಲ್ಲಿ ಮೈನರ್ ಇದ್ದಾನೆ, ಇವ್ನ ನೆಸೆಸರಿ ಏನಿದಾವೆ, ಎಸ್ಟೇಟ್ಸ್ ಇದ್ದಾವೆ, ಇವನಿಗೆ ಒಬ್ಬ ಪರ್ಸನ್ ಮಾಡಿದಾನೆ, ಅಯ್ಯೋ ಪಾಪ ಕೂಸ್ ಅಂತ ಮಾಡಾನೆ, ನೆಸೆಸರೀಸ್ ಅಲ್ಲಿ ಸಪ್ಲೈ ಮಾಡ್ಯಾನವ ಬೇಸಿಕ್ಸ್ ಎಲ್ಲ. ಈಗ ಅದಕ್ಕೆ ದುಡ್ಡು ಕೊಡಬೇಕಲ್ಲ, ಆ ದುಡ್ಡು ಯಾರು ಕೊಡ್ತಾರೆ? ಬೈ ರಿಯಲೈಸಿಂಗ್ ದಿಸ್ ಅಸೆಟ್ಸ್. ಅರ್ಥ ಆಗಿದೆಯಾ? ಆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅದು ಹೇಳ್ತಾ ಇದ್ದದ್ದು. ಬೈ ರಿಯಲೈಸಿಂಗ್ ಈಸ್ ಅಸೆಟ್ಸ್, ಇದು ಒಂದು ಎಲ್ಲ ಆಸ್ತಿಯನ್ನು ಮಾರಿ ಆ ಕ್ಲೇಮ್ ಕೇಳಬಹುದು. ಅರ್ಥ ಆಗಿದೆ, ಅರ್ಥ ಆಗಿದೆ. ಅದೇ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನೋಡ್ರಿ. ಬಟ್ ಅ ಮೈನರ್ ಇಸ್ ನಾಟ್ ಲೈಬಲ್ ಫಾರ್ ಎನಿ ಪ್ರೈಸ್ ದಟ್ ಹಿ ಮೇ ಪ್ರಾಮಿಸ್ ನೆವರ್ ಮೋರ್ ದೆನ್ ನೆಸೆಸರಿ ಆಫ್ ಸಪ್ಲೈ. ನೆಸೆಸರಿ ಆಫ್ ಸಪ್ಲೈಕ್ಕಿಂತ ಜಾಸ್ತಿ ಯಾವುದು ಬರಂಗಿಲ್ಲ. ನಥಿಂಗ್, ನಥಿಂಗ್ ಮೋರ್ ದೆನ್ ನೆಸೆಸರಿ ಆಫ್ ಸಪ್ಲೈ. ಅರ್ಥ ಆಗಿದೆಯಾ? ಅಂಡರ್ಸ್ಟ್ಯೂಡ್? ಅಂಡರ್ಸ್ಟ್ಯೂಡ್ ಬಚ್ಚು? ಬೇಗ 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 ಹೇಳ್ರಿಪ್ಪ. ನೋ ಡೌಟ್. ಮುಂದೆ ಹೋಗೋಣ. ಗೈಸ್ ಟೆಲ್ ಮಿ ಫಾಸ್ಟ್. ಓಕೆ, ಚಲೋ. ಈಗ ಲೆಟ್ಸ್ ಗೋ ವಿನ್ ಕ್ವಶನ್. ಇಲ್ಲ ನೋಡ್ರಿ, ಕ್ವಶನ್ ಐತೆ ನೋಡ್ರಿ. ಈ ಕ್ವಶನ್ಸ್ ಮ್ಯಾಗೆ, ಕೇಸ್ ಮ್ಯಾಗೆ ನಾವು ವಿ ಕ್ಯಾನ್ ಸಾಲ್ವ್ ಆ್ಯಂಡ್ ವಿ ಕ್ಯಾನ್ ಫಿನಿಶ್ ದಿಸ್. ಲೆಟ್ಸ್ ಬಚ್ಚಾವ್. ನೋಡ್ರಿ ಏನಪ್ಪ ಅಂದರೆ, ಶೇಖರ್ ವಾಂಟ್ಸ್ ಟು ಸೆಲ್ ಹಿಸ್ ಕಾರ್. ಫಾರ್ ದಿಸ್ ಪರ್ಪಸ್ ಈಸ್ ಅಪಾಯಿಂಟೆಡ್ ಮಿಸ್ಟರ್ ನಂದನ್. ನಂದನ್ ಯಾರಪ್ಪ? ಅಪಾಯಿಂಟ್ ಮಾಡಿದ ನಂದನ್ಗೆ. ಅ ಮೈನರ್ ಆಸ್ ಇಸ್ ಏಜೆಂಟ್. ನಂದನ್ ಯಾರ್ದಾನಲ್ಲಿ ಮೈನರ್ ಅದಾನವ as his agent. Mr. Sekhar instructed Mr. Nandan that car should not be sold at a price less than 1 lakh. 1 ಲಕ್ಷಕ್ಕಿಂತ ಕಡಿಮೆಗೆ ಮಾರಕ್ಕೆ ಬರಂಗಿಲ್ಲ. He cannot sell the price car for less than 1 lakh. Right? ಓಕೆನಾ? ಓಕೆನಾ ಬಚ್ಚು? ಓಕೆನಾ? ಈಗ ನಂದನ್ ಇಗ್ನೋರ್ಸ್ ದ ಇನ್ಸ್ಟ್ರಕ್ಷನ್. ಏನಂತ ಯಾರ್ದು? ಶೇಖರ್ದು, ದ ಓನರ್. ಅಂಡ್ ಸೆಲ್ ದ ಕಾರ್ to Masoom for 80,000. Explain the legal position of the contract under the Indian Contract Act 1872, whether the Shekhar owner recover the loss of 20,000 from the Nandan, illa, or Shekhar can recover loss from the Masoom. Here reply. Tell me. So very important. First case ದಾಗ ಅಂತ ನೋಡ್ರಿಪ್ಪ ಮೈನರ್ ಅದಾನೆ. ಮೈನರ್ ಕೇಸ್ ದಾಗ ನೀವು ಏನಾಗುತ್ತೆ? You cannot recover. Remember, you cannot recover anything from the law as per the from the minor. And according to provision of the section 11, according to provision of the section 11 of the Indian Contract Act 1872, a minor is disqualified. Nanepitkodri bachcho. A minor is disqualified ಆಗ್ತಾನೆ from contracting. Obviously, ಯಾವತ್ತು ಗೊತ್ತಾ? a minor ಇರ್ತಾನಲ್ಲ, he has been always disqualified from the contracting, because if you are doing any agreement with the minor, it is void agatte. Right? Now, a contract with the minor is void ab initio. Right? Void ab initio. Completely void agatte. Houdilla. However, a minor can act as an agent. However, a minor can act as an agent. When minor act as an agent, he shall bind the principal by his act. ಅಂದ್ರೆ ಈಗ ಏಜೆಂಟ್ ಇದಾನಂದ್ರೆ ಕೇಳಿಲೆ, ಏಜೆಂಟ್ ಇದಾನಂದ್ರೆ ಫಾರ್ ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್, ಏನು ಏಜೆಂಟ್ಗೆ ನಾವು ಅಥಾರಿಟಿ ಕೊಟ್ಟಿರ್ತೀವಿ, ಏನು ಕೆಲಸ ಕೊಟ್ಟಿರ್ತಲ್ಲ, ಅದು ಎಲ್ಲ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಯಾರು ಇರ್ತೈತಿ? ಆ ಪ್ರಿನ್ಸಿಪಲ್ ಇರ್ತೈತಿ. ಅಂದ್ರೆ ಈ ಕೇಸ್ದಾಗ ಶೇಖರ್ ಏಜೆಂಟ್ ಅಲ್ರಿ ನಂದನಾನೆ. However, a minor can act as an agent. When a minor act as an agent, he shall bind the principal by his act, but he will not liable to his principal for his act. ಯಾವುದೇ ಥರದ ಇವ ತಪ್ಪು ಮಾಡಿದ ಅಂದರೆ, ಯಾವುದೇ ಥರದ ಮಿಸ್ಟೇಕ್ಸ್ ಮಾಡಿದ ಅಂದರೆ ಏನಾಗುತ್ತೆ? ಎಲ್ಲ ಏನಾಗುತ್ತೆ? ಪ್ರಿನ್ಸಿಪಲ್ ಮೇಲೆ ಹೋಗುತ್ತೆ. ದಟ್ ಓನರ್, ಒರಿಜಿನಲ್ ಓನರ್ ಅವನ ಮೇಲೆ ಹೋಗುತ್ತೆ. ಓಕೆ, ಅರ್ಥ ಆಗಿದೆ? ಇದು ಅರ್ಥ ಆಗಿದೆ ಬಚ್ಚು? ಅರ್ಥ ಆಗಿದೆಯಾ? ಮುಂದೆ ಹೋಗೋಣ. ಸೊ ಇನ್ ದ ಇನ್ಸ್ಟಾನ್ಸ್ ಕೇಸ್, in the above case, Mr. Shekhar appointed Nandan, a minor, as his agent to sell his car. Mr. Shekhar clearly instructed Nandan that the minimum selling price should be 1 lakh. Yet, Mr. Nandan sold the car to Masoom for 80,000. Since Nandan is a minor and was agent, he will bind Shekhar, the principal, by his act, but he shall not liable for to Shekhar. ಅದೇನು ಲಾಸ್ ಆಗಿತ್ತಲ್ಲ, 20,000 ಬರಂಗಿಲ್ಲ. ಅದು ಅರ್ಥ ಆಗಿದೆಯಾ? ಅರ್ಥ ಆಗಿದೆ? ಯಾರ ಕಡೆಯಿಂದ ಬರಂಗಿಲ್ಲ? ಯಾರ ಕಡೆಯಿಂದ ಬರಂಗಿಲ್ಲ ಅಂದ್ರೆ, ಎಸ್, ಯಾವ್ದು ಬರಂಗಿಲ್ಲ. ಬಿಕಾಸ್ ಇವನು ನೋಡ್ರಿಪ್ಪ, ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಯಾರಿಲೆ ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ನೆನಪಿಟ್ಕೊಡ್ರಿ, ಇಲ್ಲೇ ನಂದನಂತೂ ಕೊಡಕ್ಕೆ ಬರಂಗೇ ಅಲ್ಲೇ. ನಂದನ ಎನಿವೇ ಹಿ ಇಸ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ಗಿವ್ ದ ಮನಿ. ಬಟ್ ಈಗ ವಾಟ್ ಎವರ್ ದ ಆಕ್ಟ್ agent does, it is responsibility of the principal. So Mr. Shekhar cannot recover the loss of 20,000 from Nandan, and Mr. Shekhar cannot recover his car from Masum as well. ಅಂದ್ರೆ ಅದೇ ಏಜೆಂಟಿಗೆ ನೀವು ಯಾವತ್ತು ಯಾವ್ದಾದ್ರು ಕೆಲಸ ಕೊಟ್ಟರೆ ಆ ಏಜೆಂಟ್ ಅಕಾರ್ಡಿಂಗ್ಲಿ ಇಫ್ ಕೆಲಸ ಮಾಡಿದಾನೆ, ವರ್ಕ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿಗೆ ಮುಗಿದದು. ರೈಟ್? ಎಲ್ಲ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಇರ್ತೈತಿ ಪ್ರಿನ್ಸಿಪಲ್ದ ಇರ್ತೈತಿ. ಅರ್ಥ ಆಗಿದೆಯಾ? ಅಂಡರ್ಸ್ಟ್ಯೂಡ್ ಮೈ ಡಿಯರ್ ಸ್ಟೂಡೆಂಟ್? ಅಂಡರ್ಸ್ಟ್ಯೂಡ್? Yes or no? भेट पपीपिका ತಿಳಿದಿನ ಪುಷ್ಪ? ಬೇಗ 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 ಹೇಳ್ರಿಪ್ಪ. ಅಶ್ವಿನಿ, ಪ್ರಿಯಾಂಕಾ, ಅರ್ಚನಾ, ಚಲೋ ನೋಡ್ರಿ. Okay, let's go to the next question now. Rahul is a minor falsely representing his age. He is falsely telling that ನನಗೆ 18 ವರ್ಷ ತುಂಬಿದೆ ಅಂತ ಹೇಳ್ತಾನೆ. Enter into an agreement with the shopkeeper for a loan amounting to rupees purchase of laptop. Cheating ಮಾಡಿ ಬಂದ ನಾವ. He gave his expensive watch as a security. Rahul has given his expensive watch as a security and took the loan of 40,000. He has taken a loan for 40,000. He was very happy to get 40,000 and quickly went to the market and purchased a laptop worth 30,000. He happily spent rest of the 10,000 amount with the friends and pleasure to trip. Later, Rahul realized that his watch was expensive and he should not have given like this to the shopkeeper. So he went back to the shopkeeper and asked for his watch back. Also, he refused to repay the loan amount because he's a minor. Shopkeeper disagrees to this and files a case against the minor for recovery of the loan amount. Can shopkeeper succeed in the recovery of the loan amount under the Indian Contract Act 1872? A very important point. First, I ಹೇಳಿದ್ ನಾನು ಏನಂತ, ಮೈನರ್ ಕ್ಯಾನ್ ನೆಸೆಸರೀಸ್ ಕ್ಲೇಮ್ ಮಾಡಬಹುದಾ ಅಂತ. ಅದೇ ರೀತಿ ಇಲ್ಲಿ ನೋಡಿ, ಅದು ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಪಾಯಿಂಟ್ ಇಲ್ಲಿ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ವಿ ಆರ್ ಡಿಸ್ಕಸಿಂಗ್ ಅ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಪಾಯಿಂಟ್. ಮೈನರ್ ಕ್ಯಾನ್ ಕ್ಲೇಮ್ ಫಾರ್ ನೆಸೆಸರಿ, ಎಸ್ ಆರ್ ನೋ? ನೋ, ಇಟ್ ಈಸ್ ನೋ. ಬಟ್ ಇಫ್ ಆ ಮೈನರ್ ಹ್ಯಾಸ್ ದ ಪ್ರಾಪರ್ಟಿ ಎಸ್ಟೇಟ್, ಡೆಫಿನೆಟ್ಲಿ ಹಿ ಕ್ಯಾನ್ ಕ್ಲೇಮ್ ಫ್ರಮ್ ದಟ್. ಈಗ 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 ಇಲ್ಲಾಗ್ತಾ ಇದೆ, ಶಾಪ್ ಕೀಪರ್ ರಾಹುಲ್ ಮೇಲೆ ಕೇಸ್ ಮಾಡಾನೆ. ರಾಹುಲ್ ಯಾರಪ್ಪ ಇಲ್ಲಿ? ರಾಹುಲ್ ಮೈನರ್ ಅದಾನೆ. He's a minor guy. So ಹಾಗಿದ್ರೆ ಸರ್ ಏನೀಗ ಸ್ವಲ್ಪ ನೋಡ್ರಿ. Section 11 of the Indian Contract Act, what it says is that a minor is not competent to enter into any contract. ಗೊತ್ತಿದೆ ನಿಮಗೆ? Minor cannot enter into any contract at all. ಹೌದಲ್ಲ? ಹೌದಲ್ಲ? Any agreement with the minor is completely void ab initio. Means void from the very first stage. Yes or no? Void from the first stage. First stage ಇಂದ ಏನಾಗುತ್ತೆ? ಕಂಪ್ಲೀಟ್ void ಆಗುತ್ತೆ. When a person from the agreement with the minor, such agreement is devoid. ಹೌದಲ್ಲ? ಯಾವುದೇ ಒಬ್ಬ person forms an agreement with the minor, such agreement is void of any legal consequences from the person because minor cannot be enforced by law. Against the minor you cannot enforce to the law to perform or his part or as per the agreement. When a minor fraudulently, very important, a minor fraudulently enter into a contract, bachcho, a minor fraudulently enter into a contract and the contract is cancelled, he can prove the fact that he is a minor and contract is discharged on the ground that it is void. ಒಂದಿದೆ, ಯಾವಾಗ ಒಂದು ಮೈನರ್ ಇಲ್ಲಾಗಿತ್ತಲ್ಲ fraudulently enter into a contract and contract is cancelled, ಈಗ minor he can prove that the fact that he is a minor, prove ಮಾಡಿ the contract is discharged on the ground of that it is void. However, if the minor intended to cheat, he may have to compensate. ಅಕಸ್ಮಾತ್ ಆಗಿ ಮೈನರ್ ಇಂಟೆನ್ಷನ್ ಐತಲ್ಲೇ ಏನಂತ, ಚೀಟ್ ಮಾಡ್ಬೇಕಂತ, fraud ಮಾಡಬೇಕಂತ. Got it. Got it. He may have to compensate. If the minor obtain any property by fraudulently, by representing his age, he can be ordered to restore the property. ವಾಪಸ್ ಕೊಡಬೇಕಾಗುತ್ತೆ. Or goods. Thus, whatever the obtained, although no action can be taken against the minor, but if has any property, right, if has any property in his possession, court can order to return to the same. ಏನಿದ್ರೆ ವಾಪಸ್ ಕೊಡಬೇಕಾಗುತ್ತೆ. ಅರ್ಥ ಆಗಿದೆ ಇದು? ಟಿಲ್ ಹಿಯರ್ ಅಂಡರ್ಸ್ಟುಡ್ ಬಚ್ಚೋ? ಇಲ್ಲಿ ಏನಾಗುತ್ತೆ ಇದು? ನನ್ನ ಕೇಸ್ ಇದೆ ಇದು. ಇಲ್ಲಿ ತನಕ ಅರ್ಥ ಆಗಿದೆಯಾ? ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಕ್ವಶನ್ ಬಚ್ಚೋ, ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಕ್ವಶನ್. ಟಿಲ್ ಹಿಯರ್ ಯು ಅಂಡರ್ಸ್ಟುಡ್? So guys, listen, when a minor fraudulently enter into the contract is cancelled on the ground that he is a minor, and discharge and contract is completely void. If minor intention ಇದೆ ಏನಂತ to cheat, he may have to compensate. If minor obtain any ಯಾರ್ದು ಪ್ರಾಪರ್ಟಿ ತಗೊಂಡಾನವ by fraudulently misrepresentation, he can be ordered to give it back, restore the property, or whatever the goods he has obtained. Although no action can be taken against the minor. Remember, ಯಾವುದೇ minor ಕೂಡ action ತಗೊಳಕ್ ಆಗುವುದಿಲ್ಲ. You cannot take the actions, right? But if any property in the possession, the court can order to return the same. ಅರ್ಥ ಆಗಿದಿಲ್ಲ ತನಕ? Understood? Next ಏನ್ ಸರ್ ಈಗ? In above case, Rahul is the minor, and he falsely representing his age, means his intention is to cheat. So he entered into agreement with the shopkeeper from the loan amount and purchased the laptop. He gave his expensive watch security and took a loan amount for 40,000. He spent the rest of the amount to pleasure trip. Later he went back to the shopkeeper and asked his watch back and refused to pay the loan amount. Since he was a minor, he may prove his minority, but he will have to compensate the shopkeeper here. He may have to compensate shopkeeper because he has the property, right? He has the estate. So hence, in the present case, Rahul is not liable to repay 40,000 that he has borrowed from the shopkeeper, but he can be ordered by the court to return the laptop which was in his possession to the shopkeeper. Understood? Understood बच्चों? समझ में आया? अर्थ ಆಗಿದೆಯಾ? अर्थ ಆಗಿದೆ बच्चों? So guys, this class will last till 2:30. Get ready. I'm planning to finish all the in contract act possible today itself. If not, we will continue tomorrow. Understood? Please say yes sir or no sir. ಹೇಳ್ರಿಮ್ಮ, ಅರ್ಥ ಆಗಿದೆಯಾ? ಪ್ರಿಯಾಂಕಾ, ಅಶ್ವಿನಿ, ಪುಷ್ಪಲತಾ. ಚಲೋ. Though a minor is not a competent to the contract, nothing in the contract act is prevent him from making the other party to bond the minor. Discuss, very important. Nodri, a minor idanalla, he is not competent to contract. Nothing in the contract act prevent him from making other party bond to the minor, right? So ಈಗ ಇದು ಕೂಡ ನೋಡ್ರಿ May 18 and RTP 22 ಕೇಳಿದ್ರು ಕ್ವಶನ್ಸ್. ಸೊ ದಿಸ್ ಒಂದು ಪ್ಯಾಟರ್ನ್ ಇದೆ ನೋಡ್ರಿ. ಒಂದು ಮಾತು ನೆನಪಿಟ್ಕೊಡ್ರಿ. ರಿಮೆಂಬರ್ ಒನ್ ಪಾಯಿಂಟ್ ಬಚ್ಚೋ, ರಿಮೆಂಬರ್ ಒನ್ ಪಾಯಿಂಟ್. ವಾಟ್ ಈಸ್ ದಟ್ ಮೈ ಡಿಯರ್ ಸ್ಟೂಡೆಂಟ್? ವೆನ್ ವಿ ಆರ್ ಕೇಳ್ರಿ, just have a look. A contract with minor is completely void ab initio. Was held in the case of, you can say, Mohir Bibi versus Damodar Das Ghosh. Though a minor is not competent to the contract, nothing in the contract act prevent him from making the other party to bond the minor. Andre, for example, a promissory note duly executed in favor of minor is not void and can be sued upon by him because he, though incompetent to the contract, may yet accept the benefit. ಅಂದ್ರೆ ಏನ್ರಿ ಇದರ ಅರ್ಥ? ಈಗ 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 ಮೈನರ್ ಏನು ಮಾಡಿದಾನೆ, ಪ್ರೀವಿಯಸ್ ಕೇಸ್ದಾಗ ಲೋನ್ ತಗೊಂಡಿದ್ದ, ಇಲ್ಲಿ ಏನಾಗಿದೆ ಲೋನ್ ಕೊಟ್ಟಿದ್ದಾನವ. ಅಂದ್ರೆ ಇವ ಒಂದು ಪ್ರಾಮಿಸರಿ ನೋಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾನೆ. ಯಾರಿಗೆ? ಇವನಿಗೆ, ದ ಮೇಜರಿಗೆ. ಹಾ, ಮೇಜರ್ ಹೇಳ್ತಾನೆ, ಹೋಗ ನೀನು ಮೈನರ್ ಇದಿ, ನಿನ್ ಕೂಡ ಅಗ್ರಿಮೆಂಟ್ ಆಗಂಗಿಲ್ಲ, ನಾ ಕೊಡಕ್ಕಲ್ಲ ಅಂತದಾನೆ. ಸೊ ಅವಾಗ ಇವ ಕ್ಲೇಮ್ ಮಾಡಬಹುದಾ ಅಂತ ಕೇಳ್ತಾರ ಅವರು. ಬಾಂಡ್ ಟು ದ ಮೈನರ್, ಯಸ್ ಇಟ್ ಈಸ್ ಫಾರ್ ದ ಬೆನಿಫಿಟ್. A promissory note duly executed in favor of minor is not void and can be sued upon him because he, though incompetent to contract, he may yet accept the benefit. ಏನಿಲ್ಲ ಬೆನಿಫಿಟ್ ಬರ್ತದಲ್ಲ ಅದು ತಗೋಬೋದವ. he can accept the benefit ಬಚ್ಚು. yes or no, he can accept the benefit. ಹಾಗಿದ್ರೆ ಸರ್ ಏನು? as per the section 30 of the Indian Partnership Act, minor can be a partner in a firm only for the profit, not for the loss. However, he may, with the consent of all the partner, be admitted as the benefit of the partnership. So on that case, bacho, 100% a minor can be what, bacho? Minor can enter in the contract, he can claim for his benefit. Gottagidiya? Minor can be a proposer, minor can be offer, but the person who is accepting that offer in spite of his minor, he may lose the part. Got it? Got it, bacho? Nodi. We have one more question here. Let's have a question this now. Till here understood? Understood, my dear student? Hedamma Pushpalata, Ashwini, Priyanka. No doubt? ಅರ್ಥ ಆಗಿದೆ? ಡೌಟ್ ಇದೆಯಾ? ಕೇಳ ಮಾಡೋಣ. ಡೌಟ್ ಇದ್ರೆ ಕೇಳಿ ಪ್ಲೀಸ್. Next, look, this question is a very May 22 cannot reply. Exactly 1 year back, right? One nimsha. Hello. हाँ, मैं क्लास में हूँ, मैं बाद में फोन लगा दूँ जरा. Sorry guys, ಇದು phone disturbance ಮಾಡುತ್ತೆ. Let's start now. Srishti, a minor, falsely represent her age, enter into agreement with an authorized laptop dealer, Gupta, owner of SP laptop. Srishti is a minor here. Srishti is what? Minor here. And enter into agreement with the owner of this Gupta for the purchase of laptop on credit of 60,000. On credit of 60,000. Srishti has taken laptop on credit of 60,000 for purchasing laptop. On 1st August 2021, she promised to pay back the outstanding amount with the interest at the rate of 16% per annum by 31st July 2020. Right? See, when she has issued the laptop on 1st August and she has promised to pay this much amount and just want to close the amount. She told him that in case she won't be able to pay the outstanding amount, her father, Mr. Ram, will pay back on her behalf. Exactly after 1 year, what happens, he said, if she is not able to pay the amount, or appa bandu kodtanu ಹೇಳೋಣ, ನಮ್ಮ ಅಪ್ಪ ಬಂದು ಕೊಡ್ತಾನೆ ಸರ್, ಟೆನ್ಷನ್ ಇಲ್ಲ ಅಂತ. Next, after 1 year, when Srishti was asked to pay the outstanding amount with the interest, she refused to pay the amount and told the owner that she is a minor and now he can't recover the single penny from her. Okay, she will be adult on 1st January 24. Only after that agreement can be corrected, ratified. Explain by which of the following way Mr. Gupta will succeed in the recovering of the outstanding amount with reference to the Indian Contract Act 1872. As per the 1872, ಏನಾಗುತ್ತೆ ಅಂತ ಕೇಳ್ತಾರೆ ಅವರು. ಓಕೆನಾ? ಓಕೆ, ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಪಾಯಿಂಟ್. ಸ್ವಲ್ಪ ಕೇಳ್ರಿ. First, by filing the case against the Srishti, a minor, for recovery of the outstanding amount with the interest, by filing the case against Ram, because the father of Srishti, for recovery of the outstanding amount by filing the case against Srishti, a minor, for recovering of the outstanding amount after she attaining the age of majority. Now, the very important point we are discussing, bacho, here, as per the section 11, it's all about the Indian Contract Act. Minor is not competent to enter into any contract because any agreement with the minor is void ab initio, means void from the beginning itself. Correct? When a person forms an agreement with the minor, such agreement devoid of any legal consequences for the person, because minor cannot enforce by law to perform his part and performance of his agreement, because we cannot enforce any minor to perform, to act upon the agreement. Further, bacho, this is done. Further, a minor cannot bind a parent. Remember, minor cannot bind a parent or their guardian for any act in the absence of any authority expressed or implied. Very important. A minor idanalla, minor ನಮ್ಮ ಅಪ್ಪ ಒಂದು ಕೊಡ್ತಾನೆ, ಅವ್ವ ಒಂದು ಕೊಡ್ತಾನೆ, ನಡೆಯಂಗಿಲ್ಲ ಇಲ್ಲಿ. ಯು ಕೆನಾಟ್ ರಿಕವರ್ ಬಚ್ಚೋ, ನೆನಪಿಟ್ಕೊಡ್ರಿ. ಎದಕ್ಕಂದ್ರೆ ಇಲ್ಲಿ ಏನಿದೆ, ಮೈನರ್ ಕೆನಾಟ್ ಬೈಂಡ್ ದೇರ್ ಪೇರೆಂಟ್ಸ್. ಅಪ್ಪ ಹೇಳ್ತಾರೆ ನಾನು ಮಾಡೋಣಪ್ಪ, ಅವ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿದಾನೆ, ಮೈನರ್ ನಂಗೆ, ಬಿಕಾಸ್ ನೋ ಒನ್ ವಾಂಟ್ಸ್ ಟು ಟೇಕ್ ಕೇರ್ ಆಫ್ ದಿಸ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ. ದ ಪೇರೆಂಟ್ ಈಸ್ liable only when child is acting as an agent. Parent liable ಯಾವಾಗ್ತಾರೆ ಅವ್ರದ್ದು child acting as an agent ಇದ್ದಾಗ. Parent ಆಯ್ತು, principals ಆಯ್ತು. That act also state that a minor cannot be ratified the agreement on the attaining the majority as the original agreement is void itself. ಹೌದು, at the time of majority also they cannot review or they cannot reinstate the agreement, because when the agreement is void in the first instant, you cannot reinstate. Can be, can never ratified. Hagiddare, in our case, Srishti is the minor, falsely representing her age and entered into agreement for the purchase of the laptop on credit amount of 60,000. ಈಗ ಏನಾಗುತ್ತೆ, either she has to return the laptop. ಒಂದು, on 1st August, she promised to pay the back outstanding amount after 1 year with a 16% interest. She told him that she won't be able to pay the outstanding amount. Her father will be paying back on behalf. After 1 year, Srishti was asked to pay the outstanding amount with the interest. She refused to pay the amount and told the owner she's a minor. Now he can't recover a single penny from him. She will be adult on this much. After only that agreement ratified. So, bacho, first, therefore, Mr. Gupta will not succeed in recovering the outstanding amount by filing the case against the Srishti. She is a minor. Mr. Gupta will not succeed in recovery of the outstanding amount by filing a case against Rampal, because parents cannot be bind by minor, right? As only in case of agent only that can be, right? He never authorized to purpose. So Gupta will not succeed again in recovering the outstanding amount by filing a case against Srishti after she attaining the majority. Minor act cannot be rectified. Understood? Understood, bacho? Mundoguna. Can I go for the next? Next. X is a minor, was studying in MCom in a college. On 1st July 19, he took a loan of 1 lakh. He took a loan of 1 lakh from Mr. B for payment of his college fees and purchased a book and agreed to repay on 31st December 19. X possesses asset worth. He has assets. Remember, he has assets. The minor has asset worth 9 lakh. On the due date, X fails to pay back the loan to B. B now wants to recover the loan amount of 1 lakh from X out of his asset. Referring to the provision of Indian Contract Act 1872, decide whether B would succeed or not. Remember, 100%, because what happens to the extent of assets? To the extent of asset, yes, he can succeed. Guys, this much you have to write. According to section 68 of the Indian Contract Act, if a person incapable of entering the contract or anyone whom is legally bound to support is supplied by another person with necessaries suited to his condition in the life. The person who has furnished such supply is entitled to reimbursement from the property. ಅಂದ್ರೇನು, ಈಗ ಯಾವುದೇ ಒಬ್ಬ ಪರ್ಸನ್ ಅದಾನೆ, ಆ ಮೈನರ್ ಇರಲಿ ಯಾವುದೇ ಇರಲಿ, ಇವನಿಗೆ ನೆಸೆಸರೀಸ್ ಇದ್ದಾಗ ಯಾರು ಸಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ ಕೊಟ್ಟಿದಾರಲ್ಲ, ಈ ಒಂದು ಅಸೆಟ್ಸ್ ಮೇಲೆ, ಈ ಒಂದು ಆಸ್ತಿ ಮೇಲೆ ಕ್ಲೇಮ್ ಮಾಡಬಹುದು. ದೇ ಕ್ಯಾನ್ ಕ್ಲೇಮ್ ಆನ್ ದೇರ್ ಪ್ರಾಪರ್ಟಿ, ರೈಟ್? ಸೊ ಬಚ್ಚೋ, ಈಗ in the above case, X is a minor, took a loan of rupees 1 lakh from the B for the payment, education purpose there, necessaries, college fees, and purchase the books is also necessary. On the due date, X fails to pay the back loan amount to B. Since the loan given to X is the necessaries, right, suited to the condition that in the life of the minor, so his assets can be sued and reimbursed B. Yes, bacho, B would be succeed here. Understood? Understood or not? ಅರ್ಥ ಆಗಿದೆಯಾ? ಅರ್ಥ ಆಗಿದೆ ಬಚ್ಚೋ? ಹೇಳಮ್ಮ, ಬೇಗ 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 ಹೇಳ್ರಿ. No doubt? No doubt, my dear student? Okay, next question. A student was induced by his teacher to sell a brand new car to the later at a less the purchase price to secure a more marks in examination. My God. Accordingly, the car was sold. However, father of the student pursued him to sue the teacher. State on what ground student can sue the teacher. Yes, he can sue or not, 100%. ಇಲ್ಲಿ ಏನಾಗಿದೆ, there is a student, right? His father is having car showroom, and the student teacher is forced him to sell the car at a lower price. And later the father of the student, accordingly the agreement, they have sold the car at a less price, and later on student sued the teacher. A student was induced by his teacher to sell a brand new car to a teacher at a lesser purchase price to secure a marks in exam. Accordingly, the car was sold. However, the father of the student pursued him to sue. He forced him to sue his teacher. State on what ground student can sue the teacher. Tell me. Bacho, listen. The very important. Yes, bacho, student can sue his teacher on the ground of undue influence. Right? The consent of the party is not free here. They have induced him. Get a point? So, bacho, as per the section 16 of the Indian Contract Act 1872, a contract is said to be induced by undue influence, where relation substituting between the parties are such that one party in a position to dominate the will of other party. Ilenagide, teacher is dominating other party here, the student, and he's using his power. Here they are taking his unfair advantages over the other. A person has domination position or over the other when there is a real, apparent or fiduciary relation between them. A contract induced by undue influence is voidable at the option of party whose consent is not free. So in the above case, teacher is induced the student to sell his new car at price lesser than purchase price to secure a good marks. Here, teacher and students are fiduciary relation. Means they are into a teacher and student relation there. And teacher is having dominant position in the forcing the student to contract. The contract is thus induced by undue influence here. So hence, student can sue his teacher on the ground of undue influence. On the ground of undue influence. Artha agideya? Artha agide bachcho? Tell me fast. No doubt? No doubt बच्चों. Next, discuss the essentials of undue influence as per the Indian Contract Act. Definitely, we'll discuss this one by one. And yes, guys, today I want to take a little bit longer class now. Get ready. So, बच्चों, essentials of undue influence. The very important point, essentials of undue influence. What do you mean by undue influence? When you are forcing, you are in a position to dominate. ಇನ್ನೊಬ್ಬರ ಮೇಲೆ ನೀವೇನು ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಡಾಮಿನೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ. ಯಾವಾಗ ನೀವು ಇನ್ನೊಬ್ಬರ ಮೇಲೆ ಡಾಮಿನೇಟ್ ಮಾಡ್ತಿರಲ್ಲ, ದಾಟ್ ಈಸ್ ನಥಿಂಗ್ ಬಟ್ ಅಂಡರ್ ಇನ್ಫ್ಲೂಯೆನ್ಸ್. ಫೋರ್ಸ್ ಆಗ್ತಾ ಇದ್ದೀರಾ. ಏನೋ ಒಂದು ವಾಟ್ ಇಸ್ ಸೇ ದ್ಯಾಟ್ ಅವರಿಗೆ ಡೈರೆಕ್ಟ್ಲಿ ಇಂಡೈರೆಕ್ಟ್ಲಿ ಅವ್ರಿಗೆ ಒಂಥರ ದಬ್ಬಾಳಿಕೆ. ಯು ಆರ್ ಯುಟಿಲೈಸಿಂಗ್ ಯುವರ್ ಪವರ್. So the essentials of undue influence as per the Indian Contract Act 1872 are, first is what? Relation between the party. Very important. A person can be influenced by other person when there is a near relation and two are exist. One nimsha. One nimsha. ಹೇಳಮ್ಮ, ಡೌಟ್ ಇದೆ ಏನ್ರ? ಪುಷ್ಪ, ಪ್ರಿಯಾಂಕಾ, ಟೆಲ್ ಮೀ. ಮುಂದೋಗ್ಲಿ. ಓಕೆ. ಸಿ, ದ ಪರ್ಸನ್ ಬಿಟ್ವೀನ್ ದ ಪಾರ್ಟಿ, ಅ ಪರ್ಸನ್ ಕ್ಯಾನ್ ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಬೈ ಅದರ್ ಪರ್ಸನ್ ವೆನ್ ನಿಯರ್ ರಿಲೇಷನ್ ಬಿಟ್ವೀನ್ ಟೂ ಎಕ್ಸಿಸ್ಟ್. ರೈಟ್. ನೆಕ್ಸ್ಟ್, ಪೊಸಿಷನ್ ಟು ಡಾಮಿನೇಟ್ ದ ವಿಲ್. ಬೇರೆಯವ್ರ ಮೇಲೆ ಅವ್ರದ್ದು ಒಂಥರದ ಒಂದು ಸ್ಟ್ರಾಂಗ್ ವಿಲ್ ಇರುತ್ತೆ, ಅಂದರೆ ಡಾಮಿನೇಟ್ ಮಾಡ್ತಾರೆ. ರಿಲೇಷನ್ ಬಿಟ್ವೀನ್ ದ ಪಾರ್ಟಿ ಎಕ್ಸಿಸ್ಟ್ ಇನ್ ಸಚ್ ಅ ಮ್ಯಾನರ್ ದಾಟ್ ಒನ್ ಆಫ್ ದೆಮ್ ಇನ್ ಅ ಪೊಸಿಷನ್ ಟು ಡಾಮಿನೇಟ್ ದ ವಿಲ್ ಆಫ್ ಅದರ್. Right? A person is deemed to be in such position in the following situations. Position to dominate the will of other. ಬೇರೆಯವ್ರ ಮೇಲೆ ಅವ್ರದ್ದು ಅಧಿಕಾರ ತೋರಿಸ್ತಾರೆ ಅವರು. They show that power. How, sir? Real and apparent, fiduciary relation, mental distress, and unconstitutional bargaining. We have all these. These are nothing but bacho, position to dominate the will of other. Remember, position to dominate the will of other. Now, let's start now. First, ಏನಪ್ಪ ಅಂದ್ರೆ real and apparent authority, where a person hold real authority over the other, as the case of master and servant, doctor and patient. ಇಲ್ಲಾಗುತ್ತೆ ಹೌದಪ್ಪ ಅಂಡರ್ ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಬರ್ತದೆ. ದಿಸ್ ಆಲ್ಸೋ ಕೇಸ್ ಆಫ್ ಅಂಡರ್ ಇನ್ಫ್ಲೂಯೆನ್ಸ್. ನೆಕ್ಸ್ಟ್, fiduciary relationship, where the trust and confidence exists between the parties. Trust and confidence is exist between the parties. Such type of relation is exist between father and son, solicitor and client, husband and wife, creditors and debtors, student and teachers. All right? All right? Sir, next is what? Next, bacho, mental distress. Undue influence can be used against the person to get his consent on the contract where mental capacity of the person is temporarily or permanently affected by a real reason for mental or bodily distress, illness or any of the old age. Continuous harassment ಮಾಡಿ ಅವರಿಗೆ ಆಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಳ್ಳೋದು. We are going to agree them. Next, unconscionable bargain, where one party to the contract is in a position to dominate the will of other and contract is apparently unconscionable, that is unfair. Fair ಇಲ್ಲ, full ಇದು ಮಾಡೋದು. It is presumed by law that consent must have been obtained by undue influence. Undue influence, unconstitutional bargain are witnessed mostly in money lending transactions and gifting. Unconscionable bargains अंदर होते हैं, especially that is takes place in बच्चों witnessed mostly in money lending and transactions and gift. So these are the nothing but बच्चों इधर लगता है वो, these are the essentials of undue influence where the position to dominate the will of other. Understood? Understood बच्चों? Next, बच्चों, the essentials of Undue influences are a relation between the parties, position to dominate the will. In position of the dominant will, we have all these 4 points. Any doubts you have, please ask me. Right? Okay. Next, we have the object must take undue advantages. The intention should be to take the undue advantages, where a person is in a position to influence the will of other getting consent. If their consent is not free, remember, bacho, remember, if the consent is not free, must have object to take the advantages. Means by force, by torturing them, by on the gunpoint, right? If they are taking somebody's consent, definitely. Burden of the proof. Say, if you fail to provide the proof, the burden of proving the absence of the use of dominant position to obtain the unfair advantages will lie on the party who is positioned to dominate, because if you don't have supporting documents, they can dominate you, right? So this is also another situation where we can say that the consent is not free and utilization of undue influence. So these are the essentials of undue influence under the Indian Contract Act 1872. Now, please ask me if you have any doubt, right? Come back to the point, guys. Explain the term coercion. What is that? Force. And describe its effect on the validity of the contract. Very important question, bacho. Very, very important question. See, if somebody's consent is not free, remember one thing, if somebody's consent is not free, the consent is caused by undue influence, coercion, misrepresentation, fraud. In that, coercion is very important, and its effects of validity of contracts are here. Very important point, guys. So this class will be exist till 2:30. Remember, still we have 1 hour. But as per the section 15 of the Indian Contract Act 1872, coercion is the committing or threatening to commit or any act forbidden by IPC, Indian Penal Code. In IPC, they say if you do this, you will be get penalized. So coercion is nothing but you are threatening them to some kind of making them damage, or committing or threatening to commit any act forbidden by Indian Penal Code. Or you can say that unlawful detaining. If you are detaining somebody is unlawful with the force by threatening them to kill, correct? Threatening to death or any property to the prejudice of any person, whatever, with the intention of causing any person enter into agreement. बोलते हैं मुन्ना भाई बीबीएस लगा के दो, right बच्चों, right? So it is coercion. It is immaterial whether Indian Penal Code is or not in force of the place where the coercion is employed. Coercion is employed. Bachcho, once again. Coercion employed according to section 19 of the Indian Contract Act. When the consent of agreement is caused by coercion, the contract is voidable at the option of the party whose consent is so caused. It's voidable. Remember, it is completely voidable at the party whose consent is not free. The aggrieved party whose consent was so caused can enforce, means the party whose consent is caused by coercion, who can enforce the agreement or treat it as a void. If you want, he can treat it as a void, or he can cancel. He can cancel the agreement. Now the question is that, my dear student, the injured party might insist on being placed in the same position in which he might have been had the vitiating the situations not been presenting. Means if the person whose consent is not free, in that case, what we have to do, they can be voidable at the option of the party whose consent is not free. As per the section 64, where contracts is voidable at the end, voidable means the person whose consent is not free, he can void the contract, he can cancel the contract, he can rescind the contract, and the party entitled to avoid it decided to do by canceling it, he must restore any benefit which might have been received from the other, right? Say if there are two parties here, right, and this party has received some 5 lakh rupees, and agreement between this, his consent is obtained by coercion, and he is not agreeing, but in spite of that he has been received. Now if he is canceling the, because agreement is voidable at the agreement is voidable at the option of the party whose consent is not free, so this person can reside, this person can cancel, this person can avoid the agreement, but whatever the benefit he has received, remember, whatever the benefit he has received, he has to give it back. Correct? He cannot avoid the contract and in the same time enjoy the benefit under the resigning and avoid the contract. Understood, bacho? Understood? Understood, my dear student? Tell me, any doubts you have? Tell me, guys, any doubts you have? No doubt? Pushpalata, Priyanka. Okay, next we have, it's almost 1 hour now. I need 5 minutes break. Okay? We'll start again live by, we'll start resume studying by, bacho, 1:45. 1:45. Don't go anywhere. Come back definitely till, I'll take this class till 3 o'clock and we'll try to finish this Indian Contract Act. Don't go anywhere. But you will resume this class in 15 minutes. Join agi matte. Class schedule ಮಾಡ್ತೀನಿ, join ಆಗಿಪ್ಪ. ಓಕೆನಾ? ಪುಷ್ಪಲತಾ, ಪ್ರಿಯಾಂಕಾ, ಪ್ಲೀಸ್ ಜಾಯ್ನ್ ಆಗಿರುವ ಕ್ಲಾಸಸ್ಗೆ. ಚಲೋ ಗೈಸ್, ಬಾಯ್. Okay, guys, let's resume now. Yeah, this is going to be marathon class. Bacho. Hi, Sandeep. Let's start the class. And those who have not joined Telegram channel, please join so that we can start daily live sessions for you and you'll get notification. Right, bacho? Can you hear me now? Say yes if you have not understood, please. If can you hear me, bacho? Chalo. Time's up now. Let's start now. Barama. हाँ 12 और अपडेट ಮಾಡಿ ಪ್ಲೀಸ್ ಅವ್ರಿಗೂ ಅಪ್ಡೇಟ್ ಮಾಡು okay guys next question is explain the situation in which a person is deemed to be a position to dominate the will of other person under the Indian Contract Act. ನೋಡಿ ಇದು ಕೂಡ ಕ್ವಶನ್ that's in the RTP ದಲ್ಲಿ ಕೇಳಿದ್ರು. This was previously asked in the RTP and we need to check deemed to be in a position. We need to check deemed position. When we can say that deemed position. Hi Pushpalata. ಈಗ ಡೈಲಿ ನೋಡಿ ಇವತ್ತು ಟಿಲ್ 5 o'clock ತನಕ ತಗೊಳ್ತೀನಿ ಕ್ಲಾಸ್ನ. ಆದಷ್ಟು ನಾನು ಇನ್ಕಮ್ ಇಂಡಿಯನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್ ಮುಗಿಸ್ಬನ್ನಿ ಇವತ್ತು. ಆ್ಯಂಡ್ ನಾಳೆ ಇಂಡಿಯನ್ ಸೇಲ್ ಆಫ್ ದಿ ಗುಡ್ಸ್ ಆಕ್ಟ್ ಪ್ಲಸ್ ಡೌಟ್ಸ್ ಇದ್ರೆ ಕೇಳ್ರಿ. ಪ್ರಿಯಾಂಕಾ, ಪುಷ್ಪಲತಾ, if you have any doubts, please ask me, bacha. Right? Definitely, I will be sharing all this to you. Once I finish Indian Contract Act, I will be sharing all this, bacha. Don't worry about it. Right? Chalo. So what they want? Situations in which a person is deemed to be in a position to dominate the will of, means undue influence he is using here. What is that? Undue influence he is using here. Right? Under the Indian Contract Act 1872. Bacho, a person is deemed to be in a position to dominate the will of other is, first, a person is deemed to be in such a position in the following situation. It can be a real apparent authority, fiduciary relationship, just now we discussed, mental distress, unconstitutional bargaining, correct? Unconstitutional bargaining. In these 4 cases, it is deemed to be in a dominant position. Deemed to be in dominant position. Sir, how? Let's discuss now. Real and apparent authority, where a person holds authority, strong position, like he can shout, he can use his power to dominate the will over the other, as in case of master and servants, doctor and patients. Next, fiduciary relations, where a relation of trust and confidence exists. They believe, he can do it. Getting a point? So, between the parties to contract, such type of relation exists between father and son, solicitor and client. They believe on you, right? Next, and teacher and student. Mental distress means because of old age, they are going to surrender. They are not in a position to understand. They may be a major, but they are not able to understand the conditions. Like what you can say that body distressed, or you can say they are mentally ill. So mental distress. An undue influence can be used against a person to get consent on the contract where a mental capacity of other person is temporarily or permanently affected by the reason of mental, bodily distress or illness or old age. So these are the situations where a person is deemed to be dominate the position of others. Unconscionable bargain means where one party to the contract is in a position to dominate the will of other and contract is apparently unconscionable, that is unfair. अन्याय हुआ है मेरे साथ अंतरला, अन्याय हुआ है अंतरला, some kind of unfair bargaining. Got it? It is presumed by the law that consent must have been obtained by undue influence. So unconstitutional bargaining are witnessed mostly in case of money lending. Means if somebody is in need of money, for that high rate of interest is the given transaction in that case, and even in case of gift, bacho, in case of gift also unconscionable bargaining takes place here. Understood? So bacho, these are the questions you can explain the situation under which a person is deemed to be positioned to dominate the will of other person under Indian Contract Act 1872. So bacho, remember this: real and apparent authority, fiduciary relationship, mental distress and unconscionable bargains. All right bacho. So now we are discussing about the consent which is obtained by not free. The consent which is not free means a contract which is voidable at the option of the party whose consent is not free. This one we are discussing. Just now we have done coercion. Next, second is undue influence. Third, bacho, fraud. You know what is fraud? And mere silence will amount to fraud as per the Indian Contract Act 1872, or mere silence does not amount to fraud. Discuss. Mere silence is not a fraud. Silence idre adu fraud illa. But there are some situations where silence is fraud. Explain the situation as per the provision of Indian Contract Act. Very important question, where the person is obtaining a contract without free consent by at least fraud. Got it? Hi, Vishesh. Now, let's discuss this now, how we can say that. Bacho, fraud means some kind of cheating, dhoka, anyaya, right? Under section 17 of the Indian Contract Act, fraud means, remember, fraud means, and it includes following act committed by the party to the contract. Any of the party who has committed, what is that? With the convenience, according to their convenience, they have committed this, or by their agent also, with an intent to deceive, cheat. With intent is what, bacha? To deceive, to cheat the other party to that of his agent, or induce him to enter into the contract. So which are, sir? First, giving some suggestion as a fact of which is not true. Giving some information which is actually not true. We can say it is fraud. Right? By one who does not believe to be true. Actually, it is not true, but they falsified it. Right? Next, the active concealment, hiding the fact. The active hiding the fact by one having knowledge or belief of the fact. He knows it exactly. These are the things we have to hide it. These are the things we're not supposed to give the information. These are the one which not required to reveal. Third point, a promise made without any intention to perform it is also fraud. We have done the promise and intention is to not to make a performance. Right? Not to perform the promises. That is also fraud. Or fourth point, any other fitted to deceive. Anything which is fitted to deceive. Deceive means to cheat. Anything which is we are fixed to deceive. Or any such act or omission as the law specifically declared to be fraudulent. As per the law, if you have done any kind of activity which is law says it is fraud, that is fraud. Understood? Understood, bacho? So these all about the fraud. Now question arise. What it says, mere silence will amount to fraud, means hiding information is amount to fraud. Getting my bacho? And under the Indian Contract Act, mere silence is not fraud. Keeping quiet is not fraud, because it is going to be a responsibility of other person, the person who's accept the offer, he should check, right? Cross check. See, if I'm selling something means that I have to hide some information, because not necessary that I should reveal everything, but sometimes the person who is buying, they should cross check. So under the Indian Contract Act, merely silence is not fraud here, bacho. A party to the contract is under no obligation to disclose whole truth to the other party. Obviously, when I'm selling any of my product, I don't want to reveal everything because he may not buy it. Getting a point? It's my obligation that, it's my responsibility that, or you can say that not to disclose everything. So caveat emptor, that is, let the purchaser aware of it. Let the purchase beware is the rule applicable here. The buyer should know. There is no duty to speak in such case, and silence does not amount to fraud, my dear. Silence does not amount to fraud. Similarly, there is no duty to disclose the fact which are within the knowledge of both the party. If you are giving any information, that information both the party is not required to reveal, definitely no need to pay, no need to give. However, there are cases where silence shall be treated as a fraud. Right? Some of the cases. Which are those? Here. Remember. However, there are some cases, but mere silence is not a fraud first of all, but there are certain cases. There are certain situations where, my dear student, silence is also treated as a fraud. How, sir? Look, duty of the person to speak, where the silence itself is equivalent to speech. And bacho, so these two situations. Now, where a circumstances or situation of the case are such that it is duty of the person to observe the silence to speak. Following of the contract comes within the category of the fraud where silence takes place. Which are the fiduciary relationship? We have told now, if somebody is silenced, it is the amount of fraud. Contract of insurance, they have to reveal all the information. If they are keeping silent, means again contract of marriage, yes bacho, and contract of family settlement, share allotment of contract. So these are the cases if case where the silence shall be treated as a fraud. Now, where the silence itself is equivalent to speech. Sometimes if you speak, if you are talking, for example, A says to B, if you do not deny it, it shall assume that horse is sound. A says nothing, his silence amount to speech. Got it? So, bacho, these are the points you have to remember. Fraud, you got it exactly. Fraud, where the mere silence amount of fraud, no, it is not. But there are certain situations in case of bacho, fiduciary relationship, contract insurance, contract of marriage, contract of family settlement, share allotment, all are silences amounts to fraud. And there are certain situations where silence is also equals to speech. Understood? Understood, bacho? Understood or not? Okay, coercion. Now, coercion. Exactly, bacho, voidable at the option of the party whose consent is not free is taken through coercion. Means threatening. Describes the effect on the validity of the contract. Very important. If the contract is taken place, remember, with the coercion, the party whose consent is not free because of coercion, he can be voidable. Remember, voidable contract. Right? Let's discuss this now. As per the section 15 of the Indian Contract Act 1872, coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code 1860, that is unlawful detaining or threatening to detain any property, the prejudice of any person, whatever, with the intention to causing any persons to enter into the agreement. This is called coercion. It is immaterial whether the IPC code is or not in force of place where the coercion is employed. Bacho, it is voidable at the option of the contract is void at the option of the party whose consent is not free. So according to section 19 of the act, when the consent of the agreement is caused by coercion, the contract is voidable. Remember, voidable at the option of the party whose consent was so caused. So the aggrieved party, remember, the aggrieved party whose consent was so caused can enforce agreement or can treat it as a void or can cancel it. Got it? Got it, bacho? They can cancel it. They can cancel it. Now, the injured party might insist on a place in the same position in which he might have been had vitiated the situations and not present. As per the section 64, what it says, a contract is voidable. Voidable means he can cancel the contract, and the party entitled to avoid it decided to cancel it, he must restore, he must give it back any benefit which he might have received from the previous party. So he cannot avoid the contract at the same time enjoy the benefit under the cancel or avoid. Means he has the authority, he has the power to cancel, rescind the contract. He has the power, he has the authority to avoid the contract. Understood? Understood, bacho? So now come back to the point. Situation in which person is deemed to be a position to dominate the... Okay, this is done, right? This is done. हाँ जी. Okay, guys, here we have next question and question number 2. Let's just read that now. I'll give 1 minute's time now, bacho. Read that. Karan agreed to purchase wooden table fraud he studied from Mr. X. Table was in good condition and was examined by Karan before purchasing. He has cross-checked all the table. He found no defect in it and paid 20,000 for table. Later on, it was found that one leg of the table is broken and Mr. X has pasted the wood and tried to hide the defect in the table. Can Karan return the table and claim the amount back? ಈಗ ಏನಾಗಿದೆ ಅಂದರೆ ಕರೆಂಟ್ ಮಾಡಿದ ಟೇಬಲ್ ಖರೀದಾನೆ ಪರ್ಚೇಸ್ ಮಾಡಿದಾನೆ ಯಾರ ಕಡೆಂತರ ಎಕ್ಸ್ ಕಡೆಂತರ. ಈಗ ಟೇಬಲ್ ಚೆಕ್ ಮಾಡುವಾಗ ಎಲ್ಲ ಚೆನ್ನಾಗಿತ್ತು ನೋಡಕ್ಕೆ. ಆಮೇಲೆ ಗೊತ್ತಾಗೈತಿ ಒಂದು ಕಾಲು ಮುರಿದೈತದ, ಅದು ಒಂದು ಲೆಗ್ ಇಸ್ ಬ್ರೋಕನ್. ಅವ ಈಗ ಮಾರಬೇಕಂತ ಪ್ಯಾಕಪ್ ಮಾಡಿ ಫೆವಿಕಲ್ ಎಲ್ಲ ಹಚ್ಚಿ ಮಾಡಿದಾನೆ. ಈಗ ಒಂದು ಮಾತು ಹೇಳ್ರಿ, Mr. X has pasted the wood and tried to hide the defect in the table. Can Karan return the table and claim the amount back? Discuss the same with the reference of Indian Contract Act. Nodi, this is MTP, MTP RTP to November 22. Repeat again. So, bacho, caveat emptor rule is applicable or not? Nodi, idu fraud ide illa. Nodi, idu question ide. Section 17 of the Indian Contract Act 1872, false presentation of material fact when made intentionally to cheat the other party to induce him either into a contract is termed as a fraud. How do I love? Yes or no? Yes or no? So when a party intentionally conceal, hide some material facts from the other party and make sure that the other party is not able to know the truth, in fact makes other party believe something which is false, then a fraud is committed here. Iga what they said is that bacho, when the fraud is committed, when a party intentionally conceal or hide some material fact from the other party and make sure that other party is not able to know the truth, in fact make the other party believe something which is false. False ide adana correct ide true ide anta ನಾವು believe ಮಾಡ್ತಾ ಇದ್ದೇವೆ. Got it? We are asking him to believe it. Whatever we are doing is correct. It is called committed fraud. In the case of fraud, aggrieved party has right to cancel. The party who has aggrieved, who has accepted, has the right to cancel the contract as well as claim the loss if he has suffered any. Right? ಈಗ ಚೀಟಿಂಗ್ ಮಾಡಿ ಫ್ರಾಡ್ ಮಾಡಿ ತಗೊಂಡಿದ್ದಾರೆ ನಿಮ್ಮ ಕಡೆ, ಮಾರಿದ ಮ್ಯಾಗೆ ಯಾವ ಪಾರ್ಟಿ ಇದ್ದಾನಲ್ಲ ಅವನು ಬೇಕಾದರೆ ಅದನ್ನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಬಹುದು. If agreed party has obtained some benefit, in such case contract in cause of fraud, then all benefit should be given back to the person. But in the above case, Karan agreed to purchase the wooden table from X. Table was in good condition, and when examined by the Karan, he found that no defect also. Later it was found that one leg was broken and Mr. X has pasted some Fevicol or wood, tried to hide it defect in a table. Mr. Karan has committed fraud. So because see, table ದಾಗ ಒಂದು ಭಾಗ ಇಲ್ಲ, contract become voidable, right? Contract became voidable at the option of the Karan, right? So hence Karan can cancel or rescind the contract and claim the compensation from the loss suffered due to fraud done by X. ಅರ್ಥ ಆಗಿದೆಯಾ? Understood, my dear student? Understood? Say yes sir. ಬೇಗ ಹೇಳ್ರಿಪ್ಪ. Guys, tell me fast. No doubt. ಈಗ ಇದು ಕ್ಲಾಸ್ ಆಗುತ್ತೆ 5:30 ತನಕ ನಾನ್ ಸ್ಟಾಪ್ ಕ್ಲಾಸ್ ಆಗುತ್ತೆ. ಓಕೆನಾ? Let's solve one more case now. Now, P sells by auction to Q a horse. Very interesting. This question was RTP May 19, MTP May 20, and can expect for this exam as well. You can expect this question for this example too. P sells by auction to Q an horse, which P knows it. P knows to be unsound. The horse appears to be sound, but P knows about the unsoundness. A horse huchiriyadu. That horse is mad. Who knows? The seller knows. In this contract, is this contract valid in the following situations? Tell me. If says nothing about the unsoundness of the horse to Q, if P says nothing about the Q, who is P's daughter, who has just came of age. Okay, what is that? If P says nothing about Q, and Q is who? Who is the P's daughter, who has just came of age, means majority. If Q says to P, if you do not deny it, I shall assume that horse is sound. P says nothing. Bacho, there are three cases here. Let's discuss this and let's finish this. Very interesting concept we have. So, bacho, concealing information, hiding information is also another impact, where sometimes seller wants to sell his product so that they don't want to reveal the information. But again, the question arises that whether concealing information to cheat or not, to fraud or not, that is again the question mark. So, bacho, let's discuss this. Section 17 of the Indian Contract Act merely silence as to the fact likely to affect the willingness of the person to enter into a contract is not a fraud. Very important point they're telling. What they said is that, carefully, listen, mere silence as to the fact likely to affect the willingness of the person. Mere silence about the fact which affect the willingness of the person to enter the contract is not fraud at all. However, in the following cases, silence as to the fact of the subject matter shall be considered fraud. See, both the way we should understand. Sometimes, if a person who want to enter into the contract and if you are silent about it, that affect the willingness of the person is not a fraud. Got it? But in the situations where if the condition of the case are such that regarding being hard to them, it is a duty of the person to keep the silence to speak. One thing, where his silence equals to speech. There are two conditions we have. Means, bacho, remember, mere silence as to the fact likely to affect the willingness. Mere silence to the fact likely to affect the willingness of the person to enter in the contract is not fraud. But in the following situations where silence is also result in fraud. If the situation of the case are such that regard being had to them, it is a duty of the person to keep silence to speak, where his silence equals to speech. Right? In the above case, P has auctioned an horse and sold it to Q. Correct? P knows it. What is know? Horse is unsound. Even though it looks like a sound, P fails to disclose the fact to the Q. P has not told anything about the horse. As already stated above, it is not the duty of the party to disclose any fact about the subject matter. Hence, P was under no obligation to disclose about the horse condition here. Right? Right, my dear student? Yes or no? So, bacho, remember, hence P was under no obligation to disclose whether the horse is mad or not, whether it is a sound mind or unsound mind. Thus, as per the contract, if P says nothing about the unsoundness of the horse to Q, what happens here? Thus, this contract is valid a silence is not a fraud here. First condition. If Q is P's daughter, it is duty to disclose the defect in the goods to Q. And if he fails to do so, it amounts to fraud because there is a close relationship here and there is a dominant position also we have, right? Thus, contract is not valid here. Gottaita? Understood? So, in this case, where P is silence, shows that he agrees to fact that the horse is sound and so his silence equals to speech. Ega. If Q says, P, if you do not deny, I shall assume that horse is sound mind. Neenu ಒಪ್ಕೋತಿದೆ ಅಂದ್ರೆ ನಾನು ಊಹೆ ಮಾಡ್ತೀನಿ. I'll agree that horse is sound mind. In that case, if P says nothing, in this case, P silence shows that he agreed the fact that the horse is sound, so his silence is equals to horse speech, his speech, and hence the contract is not valid here also. Right? Understood, bacho? Understood? Tell me fast. Any doubts you have? No doubt, my dear student? Okay. Sohan induced Suraj. Sohan has induced. He has some kind of force or has used some influence Suraj to buy his motorcycle, seeing that it was in a very good condition. He has said, my bike is this, that. He has polished his bike and he made it new and he wanted to sell. After taking the motorcycle, Suraj complained that there were many defects in the motorcycle. Sohan proposed to get it repaired, right, and promised to pay 40% of the cost of the repair. After a few days, motorcycle did not work at all. Suraj wants to cancel the contract. Decide, giving the reason. See, bacho, first case, what happens here? Sohan has concealed some information and to the Suraj, and Suraj complained same thing to Sohan. Sohan proposed. What he has proposed? He has proposed to get repaired and promised to pay 40% of the cost repairs. Means after a few days, what happens? The motorcycle is completely not working at all. Now Suraj want to cancel the first agreement. Bacho, here what I can say that first case itself, we can see that he has done the fraud. But after repairing, he agreed. That is why it is not the bond to. So as per the provision of the Indian Contract Act, is made based on wrong statement given by one party shall be affected by the fraud. Right? In the access, in the above, okay, the contract is induced by fraud under section 19. The agreed party can avoid, cancel. See, if somebody's consent has taken by misrepresentation false, in that case, the agreed party can cancel it. On the other hand, agreed party after becoming aware of the fraud takes back the benefit under the contract or confirm the party's losses right to the cancel and contract is valid. Ilagutte. But illenagutte. Andre ಏನು ನೋಡ್ರಿ, ಫಸ್ಟ್ ಕೇಸ್ ದಲ್ಲಿನ ಕಾಂಟ್ರಾಕ್ಟ್ ಅನ್ನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಬೇಕಾಗಿತ್ತು, ಮಾಡಿಲ್ಲ. ಹಾಗಿದ್ರೆ in the above case, Sohan induced Suraj to buy his motorcycle, saying that it was a very good condition, where in fact he had many defects. Right? The motorcycle has many defects. Sohan had defrauded Suraj in selling this motorcycle. Right? Suraj being the agreed party, Suraj is what, bacha? He is agreed party, had the right to cancel this contract. But he accepted here. What he has done, he has accepted the cost of repairs from the Sohan, thus affirming the contract. On such affirmation by Suraj, contract is now become valid. So Suraj is bound by the contract and cannot be returned the motorcycle. Right? अर्थ आगे दिया. Okay, बच्चों, next question we have. Kapil went to department store to purchase a steel pan. He went to buy some kind of steel pan. Now the question is that he asked salesman about the area of department store where the steel pans are kept. Salesman indicated him the area with the instruction that with the steel pans, other metal pans were also kept there. Kapil wrongfully picked the aluminum pan. Actually, what he wants steel pan. What he has done, he has taken aluminum pan in the place of steel pan. The salesman watched but said nothing to Kapil. Kapil reached his house and found that pan was not a steel but actually aluminum pan. Kapil filed a case against department store for fraud. Discuss whether the Kapil was eligible to file a suit fraud against department store. Right? No, we cannot, because it is an invitation to offer, acceptance, and it's a duty, caveat emptor, it's a duty of the buyer to know exactly which is the steel, which is the aluminum. Now, Section 17 of the Indian Contract Act 1872 defines fraud. We have discussed that, right? Fraud means, yes, it is induced any of the following committed by party to a contract or by his agent with intent to deceive or to induce the person to enter into the contract. How the law? That is okay, because we have discussed already. Now, in the suggestion as the fact of that which is not true by one who does not believe to be true, that is also called induce or fraud. ಏನು ಟ್ರೂ ಅಂತ ಪ್ರೂವ್ ಮಾಡ್ತಾ ಇದೆ ನಾವು, ಬಟ್ ಆಕ್ಚುಲಿ ಇದು ನಾಟ್ ಟ್ರೂ. The active concealment of facts by one having knowledge or belief of the fact. ಗೊತ್ತಿದೆ ನಿಮಗೆ ಇದು ತಪ್ಪಿದೆ ಅಂತ, ಆದರೂ ನಾವು ಮಾಡ್ತಾ ಇದ್ದೀವಿ, ಸುಮ್ ಕುಂತೇವಿ. ವಿ ಆರ್ ಗೋನ್ ಟು ಹೈಡ್ ಇಟ್. ನಾವು ಇನ್ಫಾರ್ಮೇಶನ್, ಮಾಹಿತಿಯನ್ನು ಹೈಡ್ ಮಾಡ್ತೇವೆ, ಮುಚ್ತಾ ಇದ್ದೇವೆ. A promise made without any intention of performing it is also called fraud. ಹೌದಲ್ಲ? ಒಂದು ಪ್ರಾಮಿಸ್ ಮಾಡೀವಿ ನಾವು, ಇಂಟೆನ್ಷನ್ ಇಲ್ಲ ನಮಗೆ, ಏನಂತ ಅದು ಕನ್ಸಿಲ್ ಮಾಡ್ತೀವಿ ಅಂತ, that is also called as a fraud ಬಚ್ಚು. Next, any other act fitted to deceive, anything which is like we have done any act which is which is nothing but to cheat, any such act or omission as the law specifically declares. But just now we have discussed all about this. Now, in our case, but mere silence is also not a fraud here, right? Silence amount to fraud, where mere silence is not a fraud. Silence amount to fraud where there is a duty to speak, we have to speak. If it is not fraud, right, where silence is equivalent to speech. Sometimes where we are keeping silent is also equals to speech. So if you, that is what silence amount of fraud. Now, in the above case, what happens? Kapil went to department store here to purchase a steel pan. He asked the salesman about the area of department. He says, just go and buy that store where the steel pans kept. The salesman indicated him an area with the instruction that with the steel pans, other metals also were kept there. Kapil wrongfully, what he has done, he has taken the aluminum pan in the place of steel pan, but salesman did not say anything. Later, Kapil found that pan was not a steel pan, but actually aluminum pan. Since it was not the duty of the salesman to inform what he is buying, so Mr. Kapil, about his mistake, he will not have any remedies against the salesman. So there was a no fraud. Kapil was not eligible to file a suit against the fraud in the department store. Understood? Ashwini, Pushpalata, Priyanka, Archana. Understood, bacho? Tell me fast. No doubt? No doubt, right? Next. Next question. Mr. X, a businessman, has been fighting a long drawn litigation with the Mr. Y, an industrialist. There are two guys, they are fighting for long drawn litigation. Yeah. To support his legal campaign, he enlists the service of Mr. C, a judicial officer, stating that the amount of 10 lakh would be paid to him if he does not take up the brief of Mr. Y. Mr. C agreed, but at the end of the litigation, Mr. X refused to pay the Mr. C. So decide whether Mr. C can recover the amount promised by X under the provision of the Indian Contract Act. Hingu case agta pa, yes, this is also possible, bachcho. This is also possible. So guys, remember this. Tell me, can you get that now? Let's discuss this. ನೋಡಿ ಇಲ್ಲಿ ಮಿಸ್ಟರ್ ಎಕ್ಸ್ ಅದಾನೆ, ಇಲ್ಲಿ ಮಿಸ್ಟರ್ ವಾಯ್ ಅದಾನೆ. ಇಬ್ರು ಒಂದು ಲಿಟಿಗೇಷನ್ ಇದೆ, ಒಂದು ಕೋರ್ಟ್ದಾಗ ಕೇಸ್ ನಡೆದೈತಿ, ಒಂದು ರೈಟ್. ಟು ಸಪೋರ್ಟ್ ಇಸ್ ಲೀಗಲ್ ಕ್ಯಾಂಪೇನ್ ಹಿ ಎನ್ಲಿಸ್ಟೆಡ್ ಅ ಮಿಸ್ಟರ್ ಸರ್ವಿಸ್ ಆಫ್ ಸಿ. ಮಿಸ್ಟರ್ ಸಿದು ಸರ್ವಿಸ್ ತೊಗೊಂಡವ ಯಾರು? ರೈಟ್, ಎಕ್ಸ್. ಏನು ಮಾಡಾನೆ? ನೋಡಪ್ಪ, ನಾನು ನಿಮಗೆ 10 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡ್ತೇನೆ, 10 lakh rupees ಕೊಡ್ತೇನೆ. I'll give you 10 lakh rupees. If he does not take up the brief, don't ಇವನಿದಲ್ಲ ಬ್ರೀಫ್ ತೊಗೊಳಕ್ ಹೋಗಬೇಡ. ಮಿಸ್ಟರ್ ಸಿದು ಬ್ರೀಫ್ ಡೀಟೇಲ್ ಆಗಿ ನೋಡಕ್ ಹೋಗಬೇಡ. ಅಟ್ ದಿ ಎಂಡ್ ಆಫ್ ಲಿಟಿಗೇಷನ್ ಮಿಸ್ಟರ್ ಎಕ್ಸ್ ರಿಫ್ಯೂಸ್. ಲಿಟಿಗೇಷನ್ ಮುಗೀತು, ಮಿಸ್ಟರ್ ಎಕ್ಸ್ ಅಲ್ಲ ರಿಫ್ಯೂಸ್ ಮಾಡಿ ಎಲ್ಲಿ ಹೋಗುತ್ತೆ 10 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡಕ್ಕೆ ಅಂತ ಲೀಗಲ್ ಅಂತ. ಈಗ ಹೇಳ್ರಿ, ಮಿಸ್ಟರ್ ಸಿ ಕ್ಯಾನ್ ರಿಕವರ್ ದ 10 lakh rupees? ಟೆಲ್ ಮಿ ಬಚ್ಚೋ. ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ನೋಡ್ರಿ, ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಬಚ್ಚೋ. All the agreements are contract if they are made with the free consent, right? All the agreements are contract if they are made with the free consent, right, of the parties competent to enter into contract for lawful consideration with the lawful object and not express declared void. Very important. ಈ ಕಾಂಟ್ರಾಕ್ಟ್ ಯಾವಾಗ ಅಂತೇವೆ ನಾವು? All the agreements are contract. All agreements contract ಇದಾವೆ if they are made by free consent and parties to the contract are competent enough and the object is a lawful, the consideration is also lawful and it is not declared to be void, right? Further, very important point, further Bacho, section 23 also state that every agreement which object, which intention is unlawful is void. Is void. Ile intention uddesha wrong ide. According to one of the essential elements of the valid contract, in the light of said provision, is that agreement entered into must not be which law declares to be either illegal or void. ಲಾ ಯಾವತ್ತು ಯಾವುದೇ ಅಗ್ರಿಮೆಂಟ್ಗೆ ಇಲ್ಲಿಗಲ್ ಇದೆ, ವೈಡ್ ಇದೆ ಅಂತ ಹೇಳಕ್ ಬರಂಗಿಲ್ಲ. ಹೇಳಿದ್ರೆ ಅದು ಲಾ ಏನ ಕಾಂಟ್ರಾಕ್ಟ್ ಏನಾಗುತ್ತೆ, ವೈಡ್ ಆಗಿಬಿಡುತ್ತೆ. An illegal agreement, sorry, an illegal agreement is an agreement expressly, impliedly prohibited by law, and a void agreement is one without any legal effect. ಇದ್ರ ಮ್ಯಾಗ ಯಾವುದು ಎನ್ಫೋರ್ಸಬಲ್ ಬರಂಗಿಲ್ಲ, right? In the given case, Mr. X, a businessman, has fighting a long-term litigation with the Mr. Y in the states. He enlisted a service of Mr. C, who is what? Judicial officer ima, judge adanava, stating that the amount of 10 lakh would be paid to him if he does not take up the brief of Y. Mr. C agreed, but at the end of litigation, Mr. X refused to pay Mr. C. Judge ಅಲ್ಲಪ್ಪ, right? Yeah, judge ಅದಾನವ, judicial officer ಅದಾನಲ್ಲ, he is not a solicitor, right? Refused to pay Mr. C. Such agreement is influenced with the course of justice and result of opposed to the public policy. ಹೌದಲ್ಲ, ಇಂಥ ಅಗ್ರಿಮೆಂಟ್ ಅದಾವಲ್ಲ, ಇದು ಯಾವ ಥರದ ಲಂಚ ಕೊಡೋದು, ರೈಟ್? ಲಂಚ ಕೊಡೋದು ಅಥವಾ if there is something like which is against the public policy, this can also called as an agreement in restraint of legal proceeding. So this agreement restricts one's right to enforce his legal rights. Such agreement has expressly declared to be void. Remember, such agreement expressly declared to be void under Section 28 of the Indian Contract Act. So hence, Mr. C, who's supposed to get 10 lakh, in given cases cannot recover amount of 10 lakh promised by X because it is void agreement and cannot enforce by law. ಗೊತ್ತಾಗಿದೆಯಾ? Understood? Understood ಬಚ್ಚೋ? ಅರ್ಥ ಆದಿನ ಮದ್ರಾಗ? Tell me, ಏನು ಡೌಟ್ ಇದೆಯಾ ಇದ್ರಾಗ? Any doubts you have? No doubt ಬಚ್ಚೋ? Tell me fast. No doubt? ಮುಂದೆ ಹೋಗೋಣ. Next, define misrepresentation and fraud. ನೋಡ್ರಿ, misrepresentation ಮತ್ತೆ fraud ಬಗ್ಗೆ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. Right? Explain the difference between fraud and misrepresentation as per the Indian Contract Act 1872. Very good. So ಬಚ್ಚೋ, November 20 ಕರ್ನಾಟಕ ಕ್ವಶನ್ಸ್ ಇದು ಕೂಡ ಕೇಳ್ತಾನ ಸರ್? ಎಸ್, ಕೇಳಬಹುದು. ಯು ಕ್ಯಾನ್ ಎಕ್ಸ್ಪೆಕ್ಟ್ ದಟ್. Arshwini, Pushpalata, Priyanka, tell me बच्चों, no doubt? Doubt ಇಲ್ವಲ್ಲ? ಈಗ misrepresentation and fraud means, ಬಚ್ಚೋ listen, fraud ಬಗ್ಗೆ ಅಂತ ಗೊತ್ತಿದೆ ನಿಮಗೆ. We have discussed all this just now, correct? ಹೌದಿಲ್ಲ? fraud ಬಗ್ಗೆ ಗೊತ್ತಿದೆ, ನಾನು ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ರೆ ಮತ್ತೊಮ್ಮೆ ಡಿಸ್ಕಸ್ ಮಾಡೋದು ಬೇಡ, ರೈಟ್? ಸೊ ಬಚ್ಚೋ, ಮಿಸ್ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಅಂದ್ರೆ ಏನು? ಈಗ ದ ಪಾಸಿಟಿವ್ ಅಸರ್ಷನ್ ಇನ್ ದ ಮ್ಯಾನರ್ ನಾಟ್ warranted by the information of the person making it of that which is not a true, though he believes it is to be true. ಅಂದ್ರೆ ಬಚ್ಚೋ, ಇಲ್ಲಿ ನೋಡಿ, ಮಿಸ್ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಅಂದ್ರೆ ಯಾವುದೇ ಒಂದು ಅಸಂಪ್ಷನ್ಸ್ ಅಥವಾ ಬಿಲೀಫ್ ಅದನ್ನ ಪ್ರೆಸೆಂಟ್ ಮಾಡೋದು, ರೈಟ್? ಪಾಸಿಟಿವ್, ಹೌದಪ್ಪ ಹಿಂಗಿದೆ ಒಳ್ಳೇದನ್ನ. ಪಾಸಿಟಿವ್ ಅಸರ್ಷನ್ ನಾಟ್ ವಾರಂಟೆಡ್ ಬೈ ದಿ ಇನ್ಫಾರ್ಮೇಶನ್ ಇದರಲ್ಲಿ ಬಗ್ಗೆ ಏನು ಮಾಹಿತಿ ಇಲ್ಲ. ಇಟ್ ಇಸ್ ನಾಟ್ ಗಿವಿಂಗ್ ಎನಿ ಶ್ಯೂರಿಟಿ ಆಫ್ ದಿ ಪರ್ಸನ್ ಮೇಕಿಂಗ್ ಇಟ್ ಆಫ್ ವಿಚ್ ಇಸ್ ನಾಟ್ ಟ್ರೂ, ದೋ ಹಿಸ್ ಬಿಲೀವ್ ಟು ಬಿ ಟ್ರೂ. ಅದನ್ನಿಲ್ಲ, ತಪ್ಪಿದೆ ಮಾಹಿತಿ, ಆದರೂ ಸುಳ್ಳು ಹೇಳಿ ಕನ್ನಡ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Any breach of duty which without an intended to deceive gain advantage to the person committing it. ಯಾವುದೇ ತರದ ಜವಾಬ್ದಾರಿ, ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ನೀವು ಬ್ರೀಚ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ, ರೈಟ್? ವಿ ಆರ್ one second guys. ಇನ್ನು ಸುಲಗ ಮಿಸ್ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಅಂದ್ರೆ ನೋಡ್ರಿ, ಇದು ಇನ್ಫಾರ್ಮೇಶನ್ ಬೇಕಂತ ಇಲ್ಲೇ ಹೈಡ್ ಮಾಡಿದ್ದಾರೆ, ಮಿಸ್ ಆಗಿದೆ. ಎನಿ ಬ್ರೀಚ್ ಆಫ್ ಡ್ಯೂಟಿ ವಿಚ್ ವಿದೌಟ್ an intended to deceive gain an advantage to the person committing it or anyone claiming under him by mistake another to his prejudice or to the prejudice of any other claimed under him. ಕ್ಲೇಮ್ ಮಾಡಿದೆ, ಎಲ್ಲೋ ದೋಸ್ತ್ ಎಲ್ಲಿದಿ, ಬರಂಗಿಲ್ಲ, ಅದ ಹಿಂಗೆ ನೋಡದ. ಮೂರನೇದು, ಕಾಸಿಂಗ್ innocently a party to an agreement to make a mistake as to the substances of thing which is subject to the agreement. So ಇದೆಲ್ಲ ಏನಂತ ಮಿಸ್ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಆಗ್ತದೆ. ಹಾಗಿದ್ದರೆ ಡಿಫರೆನ್ಸ್ ಬಿಟ್ವೀನ್ ಮಿಸ್ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಮತ್ತೆ ಫ್ರಾಡ್ ನೋಡ್ಕೊಡ್ರಿ. 100% ವಿ ಶುಡ್ ನೋ ದಟ್, ಒನ್ ಶುಡ್ ನೋ ದಟ್, ರೈಟ್? ಹಾಗಿದ್ರೆ ನೋಡ್ರಿ, ಇಂಟೆನ್ಷನ್ ಏನಪ್ಪ ಇಲ್ಲಿ? ಟು ಡಿಸೀವ್ the other party by hiding the truth. ಸತ್ಯವನ್ನು ಮುಚ್ತಾ ಇದ್ದಾರೆ. There is no such intention to deceive the other party. ಇಲ್ಲಿ ಆ ಲೆವೆಲ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಚೀಟಿಂಗ್ ಮಾಡೋದು ಉದ್ದೇಶ ಇಲ್ಲ, ಬಟ್ ಅಲ್ಲೇನಿದೆ, ಬಟ್ ಮಿಸ್ ಆಗಿ ರಿಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಇಂಟೆನ್ಷನ್, ಉದ್ದೇಶ ಏನಪ್ಪ ಇಲ್ಲಿ? ಟು ಡಿಸೀವ್ ಇದೆ, ಬಟ್ ದೇರ್ ಇಸ್ ನೋ ಸಚ್ ಇಂಟೆನ್ಷನ್ ಟು ಡಿಸೀವ್ ಇಟ್. Knowledge of the truth. The person making a suggestion believes that the statement is untrue. Note it. The person making a suggestion, the person who is making a suggestion, because cheating allale, ಯಾರೆಲ್ಲ ಸಜೆಷನ್ ಕೊಡ್ತಾ ಇರಲ್ಲ ಬಿಲೀವ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ, ಟ್ರೂತ್ ಇದ್ದಿದ್ದು ಅನ್ಟ್ರೂ ಮಾಡ್ತಾ ಇದ್ದಾನೆ, ಸತ್ಯ ಇದ್ದಿದ್ದು ಅಸತ್ಯ ಮಾಡ್ತಾ ಇದ್ದಾನೆ. The person making a statement believes to be true although it is not true. ಅದು ಟ್ರೂನ್ ಅಲ್ಲ, ಅದು ಇಟ್ ಇಸ್ ಆಲ್ಸೋ ಮಿಸ್ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಆಗುತ್ತೆ. ಅರ್ಥ ಆಗಿದೆಯಾ? ಅರ್ಥ ಆಗಿದೆ. ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ದಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಂಡ್ ಕ್ಲೇಮ್ ಫಾರ್ ಡ್ಯಾಮೇಜಸ್. ನೋಡ್ರಿ, ದ ಇಂಜರ್ಡ್ ಪಾರ್ಟಿ ಕ್ಯಾನ್ ರೆಪ್ಯುಟೇಟ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಂಡ್ ಕ್ಲೇಮ್ ದ ಡ್ಯಾಮೇಜಸ್. ಹೌದು, ಯಾರಿಗೆ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ ಅವರು ತಗೋಬಹುದು. ದ ಇಂಜರ್ಡ್ ಪಾರ್ಟಿ ಈಸ್ ಎಂಟೈಟಲ್ಡ್ ಟು ರೆಪ್ಯುಟೇಟ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್ or sue for the restrictions but cannot claim the damages here. Cannot claim the damages here. All right. Next, means to discover the truth. The party using fraudulent act cannot secure or protect himself by saying that the injured party had means to discover the truth. Ile party can always plead that the injured party had means to discover the truth here. Right? So these are difference. You may get a question, what is difference between misrepresentation and fraud? You should remember this. Now, explain the concept of misrepresentation in the matter of the contract. That is what we are going to repeat here. Bachcho, nodi misrepresentation andre. Bachcho, the positive assertion in a manner not warranted by the information of the person making it of that which is not true, though he believes to be true. One case. Any breach of duty which without an intent to deceive, it's a without any intent. Ile cheat ಮಾಡಬೇಕಂತ ಏನು information ಇದ್ದಿಲ್ಲ, ಇಲ್ಲಿ intention to fraud ಇಲ್ಲ, ಇಲ್ಲಿ gain an advantages to the person committing it or anyone claiming under him by misleading another to his prejudice or prejudice of anyone's claim under him. Next, causing, however, innocently a party to an agreement making a mistake as to the substance of the things which is subject matter of agreement. Right? So, let's start now. You'll get to know exactly what exactly the misrepresentation is. ಮಿಸ್ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಅಂದ್ರೆ ಏನು, ಇಲ್ಲಿ ಯಾವ ರೀತಿ ಆಗುತ್ತೆ ಸ್ವಲ್ಪ ನೋಡ್ರಿ. ಚಂದನ್ ವಾಸ್ ಸಫರಿಂಗ್ ಫ್ರಮ್ ಸಮ್ ಡಿಸೀಸಸ್, ರೈಟ್, ಅಂಡ್ ವಾಸ್ ಇನ್ ಅ ಗ್ರೇಟ್ ಪೇನ್. ಹಿ ವಾಸ್ ಇನ್ ಹಾರಿಬಲ್ ಪೇನ್. ಹೂ? ಚಂದನ್ ವೆಂಟ್ ಟು ಡಾಕ್ಟರ್ Jhunjhunwala, who was consulting fees was 300 rupees. The doctor agreed to treat him, but on one condition, that Chandan has to sign a promissory note of 5,000 payable to doctor. Oh my god, ಹೇಳ್ಕೊಡೋದು ಲಬಲಬ ಅಂತ, ಆರಾಮಿಲ್ಲಪ್ಪ ನನಗೆ ನೋವಾಗ್ತೈತಿ, ಹೊಟ್ಟೆ ನೋವಾಗ್ತೈತಿ ಅಂತ. ಬಟ್ ಡಾಕ್ಟರ್ ಏನು ಮಾಡೋಣ, ಚಾನ್ಸ್ ತೊಗೊಂಡು ಒಂದು ಕೆಲಸ ಮಾಡಪ್ಪ, 5,000 ರೂಪಾಯಿ ಪ್ರಾಮಿಸರಿ ನೋಟ್ ಪೇಬಲ್ ಮಾಡ್ತಾನೆ. Chandan signed the promissory note and gave it to the doctor. On recovery from the disease, Chandan refused to honor the promissory note because he said, I don't want to pay. State with the reason. Can doctor recover the amount of promissory note under the provision of Indian Contract Act? Hedippa, ಹೇಳ್ರಿ ಬಚ್ಚೋ ಕೇಳಲೆ. That is why it is called law. Law is a very interesting when you want to learn. ಬಚ್ಚೋ ನೋಡ್ರಿ, section 16 of the Indian Contract Act ಏನು ಹೇಳುತ್ತೆ ಬಚ್ಚೋ? Provides that contract is said to be induced by undue influence. ಹೌದಲ್ಲ? ಈಗ ಡಾಕ್ಟರ್ ತಾನೆ, ಪೇಷಂಟ್ ಅಂದ್ರೆ ಏನ್ರಿ ಸರ್ ಇದು ನೋಡಪ್ಪ, ಇದು this is nothing but bachcho, they have taken unfair advantages of dominance. Correct bachcho? So here contract is said to be induced by undue influence, where the relation subsists between the parties are such that one of the party is in a position to dominate the will of other party. So use the position to obtain the unfair advantage here. So further, the person is deemed to be in a position to dominate the will of other here. Hodala, Hodala, where he holds the real apparent authority, where he holds the real and apparent authority over the other. So we stand in a fiduciary relationship here because doctor and patient. Hodala. So where he makes a contract with the person who mental capacity is temporarily, what is that? Affected, mentally affected there. ಹೌದಿಲ್ಲ ಸೊ ಇದೆಲ್ಲ ಕಾರಣದಿಂದ section 119A provides that when the consent of agreement is caused by undue influence, when the consent of the caused by undue influence, the agreement is contract is voidable at the option of the party whose consent was so caused. Voidable contract ಆಗುತ್ತೆ ಬಿಕಾಸ್ ಏನಾಗುತ್ತೆ ಈಗ ಕಾಂಟ್ರಾಕ್ಟ್ ಏನು ತಗೊಂಡಿರಲ್ಲ ನೀವು ಇಲ್ಲಿ ಪೇಷಂಟ್ ಅದಾನೆ ಆ ಪೇಷಂಟ್ ಕಷ್ಟ ನೋಡಿ ಚಾನ್ಸ್ ಹೊಡೆದಾನೇವ he wanted to take advantages of that. Dominance ಆಗುತ್ತೆ, fraud ಆಗುತ್ತೆ. So any such contract may be set aside either absolutely or if the party who was entitled to avoid it has received any benefit from that. So upon such terms condition, the court may seem just. In the above case, Chandan was suffering from what? Some diseases and went to the doctor Jhunjhunwala, whose consulting fees was how much? 300. 300 is charged. The doctor agreed to treat him, but on the condition that Chandan has to sign a promissory note payable to the doctor. But Chandan signed the promissory note under the undue influence applied by the doctor. So Dr. Jhunjhunwala cannot recover the amount of promissory note, but he can claim his normal consultation fees of 300 rupees. अर्थ आगे दे बच्चों? Understood my dear student? ಅರ್ಥ ಆಗಿದೆ ನಮ್ಮ ಇದು? ಅಶ್ವಿನಿ ಪ್ಲೀಸ್ ರೆಸ್ಪಾಂಡ್ ಮಾಡಿ ಬೇಗ. ಆರ್ ಯು ದೇರ್ ಆರ್ ನಾಟ್? ಬೇಗ 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 ಹೇಳ್ರಿಪ್ಪ. ಅರ್ಥ ಆಗಿದೆಯಾ? ಗೈಸ್ ಮೇಕ್ ಇಟ್ ಫಾಸ್ಟ್. ಅದಿರ್ಲಿ ನೀವು. Okay. Nodi, next question there. Mr. Y. Y is what? Y is a devotee and wants to donate an elephant to the temple as a core part of the ritual worship. Mr. Y has some elephant with him and want to donate the elephant to the temple. Right? Now, worshipping is elephant is very important here. Oh my God. Right? But he contracted Mr. X who wanted to sell his elephant. Right? Mr. X contracted with Mr. Y to sell his elephant for 20 lakh. Both were unaware that elephant was dead a day before the agreement. Agreement kinta munche enagide? Elephant is died. Referring to the provision of Indian Contract Act 1872 to explain whether it is void or voidable or valid contract. ಗೊತ್ತಾಗ್ತಿಲ್ಲ ಇಲ್ಲಿ ಏನಾಗಿದೆ? ವೈ ಏನ್ ಮಾಡಿದಾನೆ? ಒಂದು ದೇವರಿಗೆ ಒಂದು ಎಲಿಫೆಂಟ್ ಕೊಡ್ಬೇಕಂತ ಪ್ಲಾನ್ ಮಾಡಿದಾನೆ. ಈಗ ಮಿಸ್ಟರ್ ಎಕ್ಸ್ ಕಾಂಟ್ರಾಕ್ಟೆಡ್ ಎಕ್ಸ್ ಹತ್ರ ಒಂದು ಎಲಿಫೆಂಟ್ ಇದೆ. ಯಾರಪ್ಪ ಇದು? ಹಲೋ, ಹೌದ್ರಿ. ಅಲ್ಲಿ ಹೋಗಿ ಮೇಡಮ್ ಬೆಟ್ಟಾಗಿ ನಾ ಕ್ಲಾಸ್ ಮಾಡ್ತೀನಿ, ಈಗ ಲೈವ್ ಕ್ಲಾಸ್ ಆಗಿದ್ದೀನಿ. ಎಲ್ಲಿದ್ದೀರಿ ನೀವು? ಮ್ಯಾಗ್ ಬರ್ರಿ, ಸೆಕೆಂಡ್ ಫ್ಲೋರಿಗೆ ಬನ್ನಿ ಪ್ಲೀಸ್. ಸಾರಿ ಗೈಸ್, ಏನು ಮಾಡ್ತೀರಪ್ಪ? ದಿಸ್ ಇಸ್ ಆಲ್ಸೋ ಇಂಪಾರ್ಟೆಂಟ್ ಫಾರ್ ಅಸ್ ಬಿಕಾಸ್ ಇನ್ಕ್ವೈರೀಸ್ ಬರ್ತಾವಲ್ಲ, ಸ್ಟೂಡೆಂಟ್ಸ್ ಇಸ್ ಆಲ್ಸೋ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಫಾರ್ ಅಸ್. ಈಗ ಎಲಿಫೆಂಟ್ ಯಾರ ಹತ್ರ ಇದೆ? ಎಕ್ಸ್ ಹತ್ರ ಇದೆ. And Mr. X contracted Mr. Y and sell the elephant for 20 lakh. Both were unaware. Y ಗೊತ್ತಿಲ್ಲ, X ಗೊತ್ತಿಲ್ಲ. Elephant was died a day before agreement. Agreement ಗೆ ಮುಂಚೆ ಸತ್ತೋಗೋದು. Right? Referring to the provision of Indian Contract Act 1872, explain whether it is void, voidable or valid. बच्चों get it. Guys, as per the Indian Contract Act 1872, mistake may be defined as erroneous. ಹೌದಲ್ಲ, ಮಿಸ್ಟೇಕ್ ಆಗ್ತಾವಲ್ಲ ಅದು ತಪ್ಪಿಂದ ಆಗ್ತವೆ. If parties to the contracts are mistake about existence of or quality or quantity of the contract, quantity of the subject matter of the, it is a mistake of the fact. Very important. ನೋಡಿ, as per the Indian Contract Act ಏನಿರುತ್ತೆ, mistake may be defined as ತಪ್ಪುಗಳು, erroneous ಇರಬಹುದು. Right? Yes or no? If the parties to the contracts are mistaken about the existence, quantity, quality, the subject matter, it is a mistake of the fact. The fact means essential facts of the contract, very important facts. When both the parties under the contract are mistaken about the essential fact, ani, elephant, of the contract, it is the bilateral mistake. ಎರಡು ಸಲ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ, ಹೌದಲ್ಲ? In case of bilateral mistake, the contract is completely void ab initio. Also, when at the time of making the contract, unknown to the both the party, the contract is impossible to perform. ಹೌದಲ್ಲ? Contract is impossible to perform here. Yes or no? Yes or no, bachcho? If the contract is impossible to perform, such contract shall be void ab initio. So the terms of the contract here implies an agreement, right? So in this case, Mr. Y contracted with X to buy an elephant for 20 lakh. Both were unaware of the fact that elephant was died day before the agreement. As both were ignorant of the fact that elephant was dead, therefore the performance of the contract was impossible. So from the starting point itself, so the contract is void, being not to be enforced by the law. Contract void ಆಗ್ಬಿಡುತ್ತದೆ, it cannot be enforced. ಗೊತ್ತಾಗಿದೆಯಾ? ಗೊತ್ತಾಗಿದೆ? Next question, ಬಚ್ಚಾ. Next question. So let me check how many we have still. 136, sir. I think we have another. Oh my God. Okay, we have 209, means 70 pages. Let's do this now. Next one. Mr. Samant owned a motor car. Samant kadeyante motor car ide. Right? He approached Mr. Chotu, right, and offered to sell his motor car for 3 lakh. Samant has a motor car and he wanted to sell it to Chotu. Mr. Samant told to Mr. Chotu that the motor car is running at a rate of 30 km per liter. That is mileage they are talking about. Both the fuel meter and speed meter of the car were working perfectly. They said speed meter and fuel meters are perfectly working. Mr. Chotu agreed with the proposal of the Mr. Samant because he has agreed it might be there, but fuel meter also good, and took the day of the car, paying 3 lakh rupees to Mr. Samant. After 10 days, Mr. Chotu came back with the car and said that the claim made by the Samant regarding fuel efficiency was not correct, and therefore there was a case of misrepresentation. Referring to the provision of the Indian Contract Act 1872, decide and write whether Mr. Chotu can cancel the contract in the above ground. Bacho, ಗೊತ್ತಾಗಿದೆ ನಿಮ್ಮ question, sir? Understood the question, my dear student? Understood this question, my dear student? Tell me fast. Understood, right? So now, ಈಗ ಸಮಂತ್ ಹೇಳ್ತಾನೆ, ನನ್ನ ಕಡೆ ಕಾರ್ ಐತಿ ದೋಸ್ತ, ತಗೋ ಅದನ್ನ, ಅದು ನಿನ್ಗೆ 1 ಲೀಟರ್ಗೆ 30 ಕಿಲೋಮೀಟರ್ ಕೊಡ್ತದೆ ಅಂತ. ಛೋಟು ಹೂ ಅಂತ ತಗೊಂಡ್ಬಿಟ್ಟಾನೆ. ಅವ ಹೇಳಿದಾನೆ ಏನಂತ, ಪೆಟ್ರೋಲ್ ಎಲ್ಲ ಕೆಲಸ ಚೆನ್ನಾಗಿ ಮಾಡ್ತೈತೆ, ಬಟ್ ರಿಯಾಲಿಟಿದಾಗ ಅದಿಲ್ಲ. ಸೊ ಇಲ್ಲಿ ನೋಡ್ರಿ, provision of the Indian Contract Act section 19, when the consent to an agreement is caused by coercion, fraud, misrepresentation. The agreement is, the contract is voidable at the option of the party whose consent was so caused. ಹೌದು ಇಲ್ಲ? Because ಇಲ್ಲಿ consent ಇದೆಯಲ್ಲ, caused by coercion, fraud, misrepresentation, undue influence is. Now, a party to contract whose consent was caused by fraud or misrepresentation, if he thinks it's fit, insists that the contract shall be performed and that he shall be put in the position in which he would have been if the presentation made have been true. Presentation made have been true iddaga, correct iddaga. That means, however, if one party tries to use the fraud or misrepresentation, right? If the one party use the fraud or misrepresentation, guys, the other party, but other party, if he would have used his diligence, would have come to know the facts of the contract shall be valid. ಟ್ರೈ ಮಾಡಬೇಕಾಗಿತ್ತಮ್ಮ, ಇವ ಏನು ಹೇಳ್ತಾ ಇದ್ದಾನಲ್ಲ ಅದು ಕರೆಕ್ಟ್ ಇದೆ ಇಲ್ಲ ಅಂತ. ಎಫರ್ಟ್ ಗಿವನ್, ರೈಟ್? However, if one party tries to use fraud or misrepresentation to induce, to sell the other party to the contract, but the other party, the buyer, that Chotu, if he would have used his diligence, would have come to the would have come to know the fact and contract shall be valid. The agreed party, the Chotu, the buyer, shall have no remedies against the other party. But in our case, someone sold his car to Chotu by making a false statement that car was running at a 30 km per liter. Both fuel eye meter and speed meters were working properly. If Chotu would have checked, he would have compelled to know about the fact. Though the someone tries to defraud the Chotu, if he would have used his diligence, would have come to know the fact. So therefore, the contract is not voidable here because Chotu try ಮಾಡಬೇಕಲ್ಲ, ಅವ ಏನು ಹೇಳಕತ್ತಾನೆ, ವಾಟ್ ಎವರ್ ಹಿ ಸೇಯಿಂಗ್ ಇಟ್ ಇಸ್ ಟ್ರೂ ಅಂತ, ಹೌದು ಇಲ್ಲ? ಅದು ಟ್ರೂ ಇದೆ ಅಂತ. ಅದು ಬಿಟ್ಟು ಸುಮ್ಮನೆ simply accepting whatever the seller is saying does not make any sense. So therefore, contract is not voidable. Hence, Mr. Chotu cannot be cancel the contract on the ground of about this one. Understood? Bacho? Next question. X agreed to become an assistant for 2 years to a Y who was a chartered accountant at Jodhpur. It was also agreed that during the term of agreement, X will not practice as a chartered accountant, okay, on his own account within minimum 20 kilometers from the office. So nodi, X he chartered accountant, he agree ಆಗಿದ್ದಾನೆ ಏನಂತ, ಅಂಡರ್ Y ಕೂಡ ನಾನು ಹೆಲ್ಪ್ ಮಾಡ್ತೀನಿ, ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತೀನಿ ಅಂತ. Y ಏನಪ್ಪ ಇಲ್ಲಿ ಸಿ ಇದಾನೆ. ಈಗ ಕಂಡೀಷನ್ ಇದೆ 2 years ಇದೆ. It was also agreed that during the terms X will not practice, X idannalla, he will not practice a chartered accountant on his own account within 20 kilometers from the office. ಈಗ X ಆಫೀಸ್ ಇಂದ್ರ 20 ಕಿಲೋಮೀಟರ್ ಒಳಗಡೆ ನಾನು ಎಲ್ಲೇ ನನ್ನ ಆಫೀಸ್ ತಗೊಂಡು ಹೇಳೋಣ. At the end of 1 year, X left the assistantship. X ಬಿಟ್ಬಿಟ್ಟ ನಾವಲ್ಲಪ್ಪ ಅಂತ of Y and started practicing his own account within the said area. ಇವನೇ 20 ಕಿಲೋಮೀಟರ್ ಒಳಗೆ ಅವ ತನ್ನ ಆಫೀಸ್ ತೆಗ್ದಾನೆ. Referring to the provision of the Indian Contract Act 1872, decide whether X could be restrained from doing so. Guys, look at that. Very important point there. Very, very important point there. Just look at that. Read that. I'll have water and back now. 1 ನಿಮಿಷ. Wait, I'll get now. Read that, I'll back. 1 minute. Okay, guys, let's start the class now. So, agreement was for how many years? 2 years, right? Agreement was for 2 years. Guys, listen. As per the section 27 of the Indian Contract Act 1872, all the agreements by which any person is restrained from exercising means which is restraint means we have retained, we have forced him to not to do exercise a lawful profession, trade, business, or any kind is to the extent is wide. Remember one thing. If any agreement which stops somebody, right, to do what lawful profession means, it may be a doctor, it may be a lawyer, it may be a CA, it may be engineer, or any kind of trade, buying and selling, right? So it is wide. However, in the case of services agreement, remember, in case of service agreement, bacho, in case of service agreement, restraint of the trade is valid. In case of service agreement, restraint of trade is valid. Restraint means stopping them, asking them to not to do. In the agreement of services by which a person binds himself, they are only agreeing during the term of the agreement not to take the service within with any else directly or indirectly to promote any of the business in direct competition. So, first of all, they cannot do the business. Yes, it is valid because in case of, my dear student, restraint of service is valid. ಮತ್ತೆ ಈಗ ನೋಡಿ ಎಕ್ಸ್ ಇದ್ದಾನೆ ವೈ ಇದ್ದಾನೆ, ಕಾಂಪಿಟೇಷನ್ ಆಗಬಾರ್ದು ಅಂತ ಇಲ್ಲಿಂದ ಅಪ್ಲೈ ಆಗ್ತಾ ಇದೆ. ಕಾಂಪಿಟೇಷನ್ ವಿತ್ that of employer is not restraint of trade. So it is also valid contract. In instant, X agreed to become an assistant of Y for how many years? 2 years here. ಹೌದಲ್ಲ? The terms of agreement were that during this term, X will not practice as a CA within 20 kilometers of the office of the Y, that is in the Jodhpur. After 1 year, X left the service of Y and started his own practice within the 20 kilometers. As the contract between X and Y was, restraint of trade was absolutely valid. So X practice was breach of contract. ಹೌದಲ್ಲ? First of all, 2 years ಇರಬೇಕಾಗಿತ್ತು. 2 years ಒಳಗಡೆನೆ, within the 2 years only he has agreed. So therefore X can be restrained. We can stop by injunction of practice. Injunction from practicing on his own account within the said area for next 1 year. For next 1 year. Understood? Understood, bacho? Next, bacho. We have next question here. Agreement. Agreement. Agreement is what? An agreement meaning of which is not certain is wide. Very important. An agreement, the meaning of which is not certain, not ಯಾವುದೇ agreement, other the meaning certain ಇಲ್ಲ, it is not certainty, is wide. ಅಂದ್ರೆ ಅಗ್ರಿಮೆಂಟ್ ಹಿಂಗಿದೆ ಅಂದ್ರೆ ಅದರ ಮೇಲೆ ನಾವು ಹೇಳಕ್ಕೆ ಬರಂಗಿಲ್ಲ ಇದು ಕರೆಕ್ಟ್ ಇದೆ ತಪ್ಪಿದೆ ಅಂತ. ಅಂದ್ರೆ ಏನ್ರಿ ಅಗ್ರಿಮೆಂಟ್ ವಿಚ್ ಇಸ್ ಲೈಕ್ ಸಮ್ ಬಾಬಾಜಿ is saying that if you dig the hole there you will get this one. Get a point? That. So बच्चों agreement which meaning is not certain is wide. How? An agreement meaning which is uncertain, which is not is a completely wide, but where the meaning of that is capable of being made certain, the agreement is valid. ಅಂದ್ರೆ ಏನ್ರಿ ಅಗ್ರಿಮೆಂಟ್ ವಿಚ್ ಮೀನಿಂಗ್ ಇಸ್ ನಾಟ್ ಸರ್ಟನ್ ಈಸ್ ವೈಡ್ ಆಗುತ್ತೆ. ಈಗ ನಾಟ್ ಸರ್ಟನ್ ಅಂದ್ರೆ ಕನ್ಫರ್ಮ್ ಇಲ್ಲ, ಅದು ಆಗುತ್ತೋ ಇಲ್ಲ ಅಂತ, ಇಟ್ ಈಸ್ ನಾಟ್ ಶ್ಯೂರ್. ಹಾ, ಬಟ್ ಇದು ನಾಟ್ ಶ್ಯೂರ್ ಇದೆಯಲ್ಲ, ಅದು ಶ್ಯೂರ್ ಆದ್ರೆ ಏನಾಗುತ್ತೆ, ವ್ಯಾಲಿಡ್ ಆಗುತ್ತೆ. ಎ ಅಗ್ರಿ ಟು ಸೆಲ್ ಬಿ 100 tons of oil. There is nothing whatever to show what kind of oil was, right? ಏನದು wide agreement ಆಗುತ್ತೆ. But agreement would have been valid if A was dealer only in conducting coconut oil. Yes, ಇದನ್ನಾಗ್ತದೆ agreement valid ಆಗಿಬಿಡ್ತದೆ. Because in such case it meaning of the agreement is coconut oil. ಹೌದಿಲ್ಲ? ಹೌದಿಲ್ಲ? Capable of being a certain entities. ಅರ್ಥ ಆಗಿದೆ? A enters into a contract with B that A sell his house for 10 lakh to B. Further, they both signed an agreement that if B uses the house for gambling purpose, idaithu nodri ನಿಮ್ದು ಕಾಂಟ್ರಾಕ್ಟ್ ಐತಲ್ಲ ಇತ್ತಲ್ಲ, then B shall pay 50,000 for it. B agreed to this. However, after 1 year of the sale, B started gambling house in the house. Can A claim that 50,000 for gambling? It is illegal contract ಆಗುತ್ತೆ. From B, discuss with reference to the provision of the Indian Contract Act. ಆಗಂಗಿಲ್ಲ. ಅದಕ್ಕೆ ಹೇಳ್ರಿ, ನೀವು ಗ್ಯಾಮ್ಲಿಂಗ್ ಕೆಲಸ ಮಾಡಲಿಕ್ಕೆ ಯಾರ್ದರ ಮನಿ ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅದು ಏನಾಗುತ್ತೆ, ಕಂಪ್ಲೀಟ್ಲಿ ಇಲ್ಲಿಗಲ್ ಆಗುತ್ತೆ. ಅಕಾರ್ಡಿಂಗ್ ಟು ಸೆಕ್ಷನ್ 24 ಆಫ್ ದಿ ಇಂಡಿಯನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್ 1872, ವೇರ್ ಅನ್ ಅಗ್ರಿಮೆಂಟ್ ಕನ್ಸಿಸ್ಟ್ 2 parts. ಎರಡು ಪಾರ್ಟ್ ಇದೆ. ಒಂದು ಮನಿ ಮಾರೋದು, ಆಮೇಲೆ ಮನಿ ಇದಕ್ಕೆ ಯೂಸ್ ಮಾಡಿದ್ರೆ ಇಷ್ಟು. Where some part of the object is legal and other is illegal, then where the legal and illegal part can be served as a divided. Again, what we are going to do? We are going to divide it. Legal part will be accepted, illegal part is separated. We have to separate now. Lawful part of the object is enforceable and unlawful part of the object is void. Whereas if both the parties are not separated, if the both parties are not separated contract, altogether it is void. If you cannot separate this part, legal and illegal part, it is void ಆಗುತ್ತೆ. In the given case, A entered into contract with B to sell his house for 10 lakh to B. Further, they both signed an agreement that if B uses the house for gambling purpose, then B shall pay 50,000. B agreed to this. However, after a year of sale, B started gambling in the house. The sale of the house and consideration paid for 10 lakh is completely valid and enforceable. However, the agreement to pay 50,000 for gambling done in house is illegal ಆಗುತ್ತೆ, and it is completely void ಆಗುತ್ತೆ. Hence, in the instance case, sale of the house agreement is valid agreement and gambling house is illegal agreement and we cannot be enforced. ಅರ್ಥ ಆಗಿದೆಯಾ? ಅರ್ಥ ಆಗಿದೆ ಬಚ್ಚೋ? ಅರ್ಥ ಆಗಿದೆ ಬಚ್ಚೋ? Can you go for the next? हाँ जी. Tell me. State with the reason. So July 21. These are the questions they have asked, but you get ready for this. State with the reason whether the following agreements are valid or not. A clause in a contract provided that no action should be brought upon the case of breach. Case of breach, not breach. Now, bacho, clause of the contract states that a clause in a contract provides that no action should be brought upon in case of breach. Bacho, the agreement is void because so if in case contract breach ಆದರೆ ಅದ್ರ ಮ್ಯಾಗ ಯಾವುದು ತರದ ಟರ್ಮ್ಸ್ ತಗೊಳಂತೆ. ಸೊ ನೋಡಿ, the given agreement is completely void. It is why, as per the section 28 of the Indian Contract Act, this clause is restraint of legal proceeding. It's stopping to take enforceability. It is not allowing to take action if the contract is breached. So it is agreement is void because it restricts both the party from enforcing their legal rights. So note that alternately, as per section 23 of the Indian Contract Act 1872, this clause in the agreement defeat the provision of the law and therefore being unlawful is treated as a void. Understood, bacho? Understood, my dear student? Understood? So second question. Where two courts have jurisdiction, try a suit. An agreement between the parties that the suit should be filed in one of these court alone and not in other. The two courts have jurisdiction to try to suit here. An agreement between the parties that the suit should be filed in one of these court alone and not in other court. So the given agreement is void because one court case unta irtadi. So reason, an agreement in restraint of legal proceeding is the one by which any party to that is restricted absolutely from enforcing his right under the contract, though a court through a court. A contract of this nature is void. However, in the given statement, no absolute restriction is marked on the parties on filing a suit. As per the agreement, suit may be filed in one of the court having the jurisdiction. Right, bacho? So next question. Doubt kedamma idraga. Any doubts you have, please ask me, bacho. No doubt, bacho? Doubt kedಬಹುದು. You can ask me any doubts you have. Doubt ilvalla? X offered to sell his Maruti car to Y. Y believes that X has only WagonR but agrees to buy it. X is selling Maruti car. Y believes that X has only one car, that is WagonR. Now the question is that, bacho, it's completely void agreement. Why, sir? Nodi, two parties thinking of different things, right? Consensus addendum means not understanding same thing in same sense. Correct? Howdilla? So the agreement is void as two parties thinking about different subject matters, so that there is no real consent here. Right? Consent is not the same here. And the agreement may be treated as a void. So because of mistake of fact as well as absence of consensus. X is a physician and a surgeon, employs Y as the assistant on the salary of 75,000 per month for the term of 2 years. Y agrees not to practice as a surgeon, as a physician during these 2 days. 2 years. Bacho, is that agreed? Yeah, it is. It's a valid agreement. How the law? It is valid agreement, bacho. Why? Reason, an agreement by which any person restrained from exercising lawful profession, trade, business, correct, or any kind, is to the extent void. But as exception, agreement of services by which employee bind himself during the terms of this office. ಅರ್ಥ ಆಗಿದೆಯಾ? ಅರ್ಥ ಆಗಿದೆ ಬಚ್ಚೋ? ಏನು ಕಾಲ್ ಬರ್ತಾವ್ರಿಪ್ಪ ನನಗೂ. अब मैं लाइव क्लास में क्या क्या शिफ्ट खत्म ही मजे में लाइव क्लास में तो बच्चे सुनते रहते हैं मजे में. बस हो गया है। पेट्रोल क्लास हुआ था तो मुझे फोन क्यों लगा रहा, तू तुझे पेट्रोल लगा नहीं हुआ? अब मैं क्या करूं बोल? फिर आया फोन लगा क्लास नंबर। ಗೈಸ್ ಸಾರಿ ಫಾರ್ ದ್ಯಾಟ್. ತರ್ಟಿಪ್ಪ ನನಗೆ ಒಂದು ಕೆಲಸ ಬಂದಿದೆ. ಇದು ಯಾ ವಿ ಹ್ಯಾವ್ ಆಲ್ ದೀಸ್ ನಾವು ಇದೆಲ್ಲ ಮುಗಿಸ್ಬೇಕಾಗಿತ್ತು. ವೆಗ್ರಿಂಗ್ ಅಗ್ರಿಮೆಂಟ್ ಇದೆ, ಮುಗಿಸೋಣ ಇವತ್ತು ಅಟ್ ಎನಿ ಕಾಸ್ಟ್ ಗೈಸ್. ನೋಡು ನಾನು ರಾತ್ರಿಗೆ ಇಲ್ಲ ನಾಳೆ ತನಕ ಇದು ಮುಗಿಸ್ತೇನೆ. ಕಾಂಟ್ರಾಕ್ಟ್ ಮುಗಿಸಿದ ಮ್ಯಾಗೆ ಸೇಲ್ ಆಫ್ ದಿ ಗೂಡ್ಸ್ ಆ್ಯಕ್ಟ್ ಮುಗಿಸ್ಲಿಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡೋಣ ಬೈ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ತನಕ. ಸೊ ಸೇಲ್ ಆಫ್ ದಿ ಗೂಡ್ಸ್ ಆ್ಯಕ್ಟ್ ಮುಗಿತಪ್ಪ ಅಂದರೆ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಇದೆ, ಆಮೇಲೆ ಯಸ್ ವಿ ಕ್ಯಾನ್ ಫಿನಿಶ್ ಇಟ್. ಈ ರೀತಿ ನೋಟ್ಸ್ ಅದಾವೆ, ಕಳಿಸಿರ್ತೀನಿ, ದಯವಿಟ್ಟು ಡೈಲಿ ಜಾಯ್ನ್ ಆಗಿರಿಪ್ಪ. ಅರ್ಚನಾ, ಪುಷ್ಪ, ಎಲ್ಲರೂ ಓಕೆನಾ? ಚಲೋ ಗೈಸ್, ವಿಲ್ ಕಂಟಿನ್ಯೂ ಇನ್ ದ ನೆಕ್ಸ್ಟ್ ಕ್ಲಾಸ್. ಡೌಟ್ ಇದೆ ಏನ್ರು? ಎನಿ ಡೌಟ್ಸ್ ಯು ಹ್ಯಾವ್?